hear ye, hear ye. All persons having business to do before this court will draw near, give their attendance, and they shall be heard.
Good morning, everyone. You may be seated. First case for oral argument will be 1292 People v. Thomas. Justice Winslow is recused. Good morning.
Good morning. May it please the court. I first want to address point number 4 in my brief, that the trial court erred in allowing Cedric Young, Juan Ocasio, I'm not sure if I'm saying it right, and the deputy whose name I'm not going to pronounce correctly, to over defense objection to testify in this case. Cedric Young and Juan Ocasio were probation officers who they testified that my client was present in a building at the same time that the complainant was.
Why isn't that relevant?
The complainant would never identified my client. Mr. Allen was never asked to identify my client.
But he said that he recognized the defendant in that building, and there was confirmation that the two of them were in the building at the same time. So
no confirmation that they saw each other. No confirmation. Mr. Allen
I thought the testimony was the defendant said he saw the individual who robbed him in the same building he was in, the probation building. Isn't that what he stated? He
stated that he saw the same person that robbed him in the same in the building. Yet he couldn't identify him. He never identified at trial. He didn't. He neither identified my client as the person that robbed him, nor did he identify him as a person who was present in the probation department at the same time.
Can't you build it piece by piece? Is this just a small piece in the identification equation here?
The identification is tenuous, and that's being very kind. There was no identification in this case. The complainant never identified the defendant. He never identified him as a person who robbed him at gunpoint. He was close enough to take a bus pass out of his hand. The alleged perpetrator took a bus pass out of his hand. And he wasn't able to identify him as the person who robbed him. He also, allegedly saw him during daylight conditions in the probation department. He didn't identify him.
The victim was a reluctant witness. He was forced to appear. He was brought in on a material witness order, wasn't he?
Yes, he was. But of course the identification issue backs up with a Brady violation. There's a
Brady violation because you're saying that the people knew in advance that he wasn't going to be able to identify him in the courtroom?
Yes, Your Honor. There was a break in testimony and an offer of proof, however, and Mr. Allen's attorney, Yvette Ganguly, was brought in, and it was very tenuous as to what Mr. Allen was going to say.
The difficult part here is we take into consideration the direct and the circumstantial evidence, and as Justice Joseph alluded to earlier, piece by piece. And there's other evidence, the jailhouse individual, there's other evidence that we have here that ties him into the crime other than...
Well, there were 3 jailhouse informants, and two of them said that my client said he was in jail for two murders and a robbery. At no time did any of the jailhouse informants say that my client identified the date, the robbery, any circumstances. Now, everybody's in jail for something. He wasn't. They're there on charge. They're unless they're a sentenced prisoner, they're there pending charges. So, the fact that he may have stated that he was in jail for charges, I don't think is an admission of guilt. And the third jailhouse snitch was John Bradley, who admitted that he had reviewed the defendant's discovery packet. He's the only person that identified the complainant by name, and that was, again, only after he admitted that he had read through and knew very specific information from the discovery packet.
We have your argument. Thank you.
Thank you.
Good morning.
Good morning, Your Honors. In regards to the testimony of the probation officers, it wasn't just the testimony of Marcus Allen that he saw the person that robbed him the day after the robbery at probation that made that testimony relevant. It was also the testimony of Jerome Bradley, one of the jailhouse informants, who testified also that the defendant had told him that he had seen the person he robbed at probation the day after the robbery, and he was concerned that that person was going to come in and testify against him. And that was in the context of trying to hire Jerome Bradley to murder the witness who he had robbed after Jerome Bradley was released from jail. So that testimony was highly relevant, and it was properly admitted at trial. In regards to the Brady issue, the testimony was very clear, not only from the district attorney, but also from Mr. Ganguly, Mr. Allen's attorney, that Mr. Allen never told the district attorney that he was going to be unable to identify the defendant. He expressed concern. He wanted to know what might happen if he was not able to identify the defendant, which I think is a reasonable concern a year and a half after the crime for a witness to want to know, especially a witness who is in on a material witness order, to want to know what might happen if he can't identify. But that's not the same thing as saying either I can identify the person that robbed me, or I can't identify the person that robbed me, and that is not the defendant. Either of those things could be a Brady violation, but that's not what happened in this case. Was there any other questions? Thank you.
1295, People v. Stumbo. Justice Winslow's recused. Good morning.
Good morning, Your Honors. May it please the Court, Kara Waldman representing Ms. Stumbo. I would like to focus most of my argument on point 1 of my brief, that Ms. Stumbo was denied the effective assistance of counsel based on defense counsel's numerous errors. The most egregious error occurred when defense counsel elicited favorable Sandoval during direct examination of Ms. Stumbo. There was no plausible strategic reason for defense counsel to ask Ms. Stumbo about her prior drug conviction in California. It was highly prejudicial. It made Ms. Stumbo out to be a druggie in the eyes of the jury in a drug possession case.
So the district attorney kind of concedes that point. But do you think that in and of itself is egregious enough?
Well, my argument,
I know you have other aspects of ineffective
right.
assistance, but you think that in and of itself on its own?
I would hope that the court would agree that that in and of itself was egregious enough under Turner to constitute ineffective assistance, but I also, as you stated, Justice Centra, have other instances of ineffective assistance. The people cite to Reitz in their brief for the proposition that this did not amount to the ineffective assistance of counsel, but that case is distinguishable. In Reitz, defense counsel asked the defendant, who was charged with burglary, about a prior burglary charge or conviction during direct, even though this conviction had been precluded. In Reitz, however, the prosecutor did not ask the defendant on cross about the conviction, and the judge gave a limiting instruction. In this case, the prosecutor did ask Ms. Stumbo about the drug conviction in California, and there was no limiting instruction. I cited 2 People v. Webb in my brief, and I think that case is more on point, but I think here it's even more troubling. In Webb, the court allowed the prosecutor to question the defendant about 3 convictions, but precluded the 4th conviction.
Well, the problem with Webb was the fact that they precluded the 4th, the defendant mentioned the 4th, and the DA ran with it at that point, and that was a problem with Webb, was the DA just continued going on, asking questions, and utilized, I even think, in cross-examination. And in Webb, we found that that had gone too far. In this situation here, we have it where she's mentioned she's conviction on cross-examination. I think the district attorney they talked about whether it's 23 or 25 years. I don't believe I saw it mentioned in summation, but I'll stand corrected if you have a better recollection of that. And so it doesn't seem like he really made a big issue on that in of itself, that fact that came out.
But I guess the way that I see Webb as on point with this case, and even more troubling, is that there were 4 convictions that were elicited in Webb, and here there was only 1 conviction that was elicited, and here it was a drug conviction.
Did Webb also have flight? And Webb was a case that involved flight, and the defendant's prior conviction that he wasn't supposed to get into involved flight.
Right,
And so wasn't that part and parcel of the court's analysis here?
Yes, I agree with that. But here, the fact that the prosecutor asked her about the date, went to her credibility and could show to the jury that she was lying.
I think we have that.
Okay. With respect to the other issues or the other errors, defense counsel also admitted guilt on summation regarding possession of the drugs. He elicited damaging and highly prejudicial testimony that would otherwise be inadmissible. Once it was elicited, the door was open for the prosecutor to question Ms. Stumbo repeatedly about this testimony, which painted her as a druggie. For example, defense counsel asked Ms. Stumbo about a prescription for hydromorphone and fentanyl patches that showed that she had a motive to possess the drugs because
wasn't it also the fact that there was patches involved, and the defense strategy might have been the fact that she didn't need him to steal the patches because she has a prescription for them, and is that part of the defense strategy? We're looking here at whether or not there's any defense strategy whatsoever. And going back to your first issue, dealing with making the admission, I've read the closing argument, and it appears that the attorney was paraphrasing in anticipation of what the prosecutor said and is going to say. Not that he got up there and conceded to it. He says, this is what you're going to hear, and this is what you did hear. And it was really paraphrasing, I believe, what the prosecutor said. So I don't know if I want reading that. I take that as he admitted guilt. I mean, part and parcel of it was she was acquitted of it with possession with intent to sell. And that was, at the end of the day, I don't know if it mattered much, but as a result of the sentence.
Right. Well, I guess the way that I look at it as he initially admitted guilt on summation, but then I think he said that she didn't possess the drugs later on in his summation, and then later said that she didn't knowingly possess the drugs. So
well, you have to admit, it's a difficult situation. We have a defendant who I don't want to make light of it, but is audio or is on tape with her son in jail, and they're telling one another, please be careful because we're being taped, and then they go on to admit the whole crime on the tape. And so they got her admitting to it, and her argument was, and you're tidying your ineffective assistance, was that she lied to him. She was lying to him over the phone just to appease him. That was her defense. That's what because she had to take the stand because they had her admitting to the crime on the audio. Correct?
Correct.
So it wasn't as straightforward as that. I mean, the defense lawyer here had a difficult road to hoe with what evidence that was piled up against her.
But I guess just focusing on weight now, we're really looking only what occurred on May 14th, which is a 6-hour window from 6 o'clock when the robbery occurred. So, the question to the jury was, did she possess the drugs during that 6-hour window, and not what occurred later on the tapes? Those occurred the following day and several days later. Okay. And just to sum up, even if we assumed that she did possess the 300 pills and the 10 patches that weren't recovered, which I think that was the theory that the jury used to convict her, that amount would not have an aggregate weight that was high enough to convict her of criminal possession in the first degree. Thank you.
Good morning.
Good morning, Your Honors. As I indicated in my brief, I believe that there is one error that fairly can be ascribed to defense counsel, and that deals with the Sandoval ruling and his going beyond what the judge had limited to. But there was just one question from defense counsel on that, one question from prosecutor on that, and that was it from the rest of the case. No other mention, in summation, or anywhere else. And as you've indicated, Your Honor, this really was a case with overwhelming evidence. And therefore, I've cited several cases indicating that isolated errors, when you look at the big picture, by counsel aren't sufficient to warrant a reversal. The other topics that I wanted to cover, Your Honor, I believe have been adequately covered in your discussion with defense counsel, so unless there is any other questions or any other questions, I'd be happy to rest on my papers.
Thank you, counsel.
Thank you.
$12.96, People v. Martin Brown.
Good morning.
Morning.
19-year-old Antonio Martin Brown and 62-year-old Vincent Catone had been in an intimate relationship for more than 6 months. During a prearranged meeting at Catone's home about the $800 that Appellant had taken from his checking account, Catone verbally attacked Appellant and then started choking him. The evidence establishes we believe that Appellant snapped and struck Catone more than 100 times with objects from Catone's bedroom, inflicting in less than 15 minutes horrible, fatal injuries. However, it just makes no sense that Appellant lashed out in this brutal and shocking way because he was worried about a petty larceny charge.
This is all leading to your EED defense?
Yes, Your Honor.
Okay, and let's not leave out the fact that he left and came back to make sure he took the, I believe, the straight edge or whatever, box cutter and his cell phone because he was afraid it was going to lead him to him, which becomes a factor down the road when determining the EED defense.
Well, Mr. Antonio Martin Brown testified that he has no recollection of what he did at the time, and I think it matters at the time of the infliction of the terrible injuries. He may have recovered some kind of memory after the time, and this also relates to the inappropriateness of allowing the people's psychiatrist to testify.
On rebuttal.
I beg your pardon?
On rebuttal?
On rebuttal. Defense counsel maintained all throughout this trial that this case could be decided on the facts. But unfortunately, during the pretrial proceedings...
Didn't he consent to having the people's expert interview?
Yes, he did. Yes, he did. And he is very honest and forthright later in the trial and in the proceedings, admitting that he made a mistake. And indeed, he did make a mistake, because when you read the testimony of the psychiatrist at trial, it becomes clear that he has absolutely no expertise about extreme emotional disturbance, nor did he conduct any investigation into Appellant's background or Appellant's relationship with Mr. Catone. We submit that the doctor's testimony was simply not probative on the only issue at this trial, which was extreme emotional disturbance. And the court could have decided this EED issue without any expert testimony.
Yeah, but it doesn't, whether expert or not, they're entitled to it. The case you cited to in the Court of Appeals cases deal with when the defense makes out a case of EED with the prosecutor's proof. But if a defendant puts on a doctor, which he didn't hear, or the defendant or other witnesses testify towards an EED defense, it's perfectly appropriate for the allowed rebuttal. And I think Diaz and was it Martinez or whatever those other cases, I think they hit it head on.
Well, our reading of those cases is that it was discretionary with the trial judge. And this defense counsel at least should have argued with the trial judge whether it was appropriate to have his client submit to the people's psychiatrist.
And I think the court down below had that standard kind of mixed up too.
And our main argument is that this case is no different from the cases in our brief where other appellate courts have found that EED was proven by a preponderance of the evidence or the weight of the evidence, and we ask that the murder conviction be modified to manslaughter in the first degree, or that Mr. Antonio Martin Brown be granted a new trial on grounds of ineffective assistance.
Thank you, counsel. Good morning.
Good morning. As my opponent points out, the evaluation was consented to by the defense, so there's no reasonable construction that would allow that claim to be preserved. As far as it being the basis for an ineffective claim, I would suggest that it was a tactical concession, given that the notice was late. By consenting to it, counsel is put in the position of saying, well, there's no prejudice to the people because they can have their evaluation. And as the court rightly pointed out, the whole purpose of the notice provision is to permit the people an opportunity to obtain any mental health evidence necessary to rebut the defense, which defendant did present here, as the court noted. So long as he's the proponent of the evidence, it is irrelevant that it is either derived from lay or expert testimony. As weight and sufficiency goes, Your Honor, I think Dr. Horowitz's testimony was extremely probative, particularly when he said that defendant's conduct was simply most consistent with anger. And that, of course, does not satisfy defendant's burden under EED. And when you couple that with evidence of defendant's post-crime conduct, going back into the home to obtain the cell phone and the box cutter, it suggests that he had full command of his faculties and consciousness of guilt. So I would ask the court to affirm the judgment, unless there are any questions.
Having none, thank you. Thank you. 1297 People v. Pruitt.
Good morning, Your Honors. Danielle Wild for Ms. Pruitt. May it please the court. Once the stop and frisk of Ms. Pruitt revealed that she did not possess a gun, the continued detention of her was unlawful. According to the Court of Appeals precedent in Molaski and Banks, once an officer's initial suspicion is dispelled, any continued detention beyond that point, especially escalating the level of detention beyond that point.
That's the question, though, whether the officer's suspicion was dispelled. There was a purse lying on the ground. There was another person there. The officer had received a 911 call about a woman matching the defendant's description, possessing a gun. So when he didn't find a gun on her person, wasn't he permitted to continue his investigation?
Respectfully, not to the level that he did. The 911 call indicated that there was a black female with red hair, a black leather jacket who had a gun. The 911 call said nothing about a purse, a gun being in a purse, and certainly the reliability of that 911 call is unclear, as we argue in our brief. Under our gyrus, it's kind of it's a little bit unclear.
Well, you'd have to agree that's a little unusual circumstances of the description, and the officer arrives on the scene within 5 minutes and sees someone who fits the description, sees as Justice Perot also sees the path in which she walked, detains her momentarily to find out what's going on, and goes back to the path that she walked and finds a purse. And I think, to me, the more pointed point comes in is once he says, "Is this your purse?" and she says yes, then the question becomes, is there anything in there that I should be concerned about? And I think that, to me, that gets us to the point of whether or not that's, you know,
well, to that point, Your Honor,
as opposed to investigatory.
Well, sure. To that point, that question was in violation of Miranda. It's clear that Ms. Pruitt was in custody at that point. She was handcuffed, frisked, placed in the back of a police car.
She's in custody. So now the question is, those two questions that Justice Sentra posed that were asked, are those, you know, the further investigation or are they accusatory?
Certainly, in this case, they are interrogation for Miranda purposes. The question, is this your purse, was reasonably likely to elicit a response that people would seek to introduce at trial.
You have to admit on the first question, he finds a purse. It's been abandoned because he finds it on the ground in the middle of the night. And he says, "Is this your purse?" She could have simply said no. Maybe he's trying to find out who's the owner of the purse before he goes into the purse and checks the ID. I don't see a problem with him asking the purses. I think the more pertinent question is that once she says it's hers, is the question is there anything in there I should be concerned about?
Well, certainly that question is problematic, especially in light of this court's precedent in Long and Leitner. This case is incredibly similar to Long, in which while the defendant was in the back of a police car, after he had been pulled over for an expired registration, the officer asked, "Is there anything in the car that I should know about before it's towed?" And this court held that that question was interrogation for Miranda purposes and suppressed that statement, suppressed the gun that they found in the car and the subsequent statements as part of a continued interrogation.
With respect to that second question, would you agree that the defendant's response was not incriminatory?
No, I would not, because whether a statement is incriminatory has a very broad definition for Miranda purposes. It's any statement that the people may seek to introduce at trial. And if she says, nope, there's nothing in my purse, certainly the people are going to seek to introduce that at trial too, to go towards the defendant's credibility. If she says, yes, there is something in my purse, and that admission is something that the people are going to seek to introduce. Regardless of what her response is, the people are would reasonably likely seek to introduce that statement at trial, and that makes it an interrogation for Miranda purposes.
You've also raised the question of when the purse was opened or who opened it, or how
Yes.
did it become open? How did the gun become exposed?
I did. The people argued that this search was justified by the Plainview Doctrine. It was not. This was not an inadvertent discovery of the gun in the purse. The testimony Officer Abrams was entirely equivocal. He said 3 times he wasn't sure whether the purse was opened or closed when he first found it. He wasn't sure whether it was zipped or unzipped. He said that twice.
He did say, that's absolutely correct, but he did say when he placed it on the car, it opened up, and that's when he saw the gun inside.
Well, my recollection of the testimony was that what he actually did is he placed the floppy purse on top of the trunk, put the handles to the side, and then visually looked through it. That's not an inadvertent, oh, I just plopped it on top of the trunk and the gun popped out of it. He specifically set it on the trunk in such a way that he could look inside. And Officer Gabrowski, when he testified at the hearing, said that when he arrived on scene and Officer Abrams advised him of what had been going on, he said, I found this gun in the purse, and I quote, I maybe opened it up just a little bit. That's certainly, however he opened it up, whether it was by separating the handles, whether it was by unzipping it a little bit, that makes it clear that this was not an inadvertent discovery of the gun.
Thank you.
And so unless the court has any further questions, I'll rest on my brief for the remainder.
Thank you, Counsel. Good morning.
Good morning again, Your Honors. The questions asked by Officer Abrams of the defendant after he located the purse were investigatory. They were not
let me ask you this.
Yes.
This is the inconsistency. We're dealing with 2 principles of law here. We're dealing with DeBoer, and then we're dealing on whether or not, I think you concede she was at least de facto in custody.
I would, yes. She was in handcuffs in the back of the police
And you would
car.
agree that this was a level 3?
Yes.
Okay. So the inconsistency in my mind, and I don't know if it makes a difference for our analysis, is on the one hand, we say, well, you know, she's in custody, and just by frisking her and finding nothing, the officer's conduct was proper because they got this call. She was with another individual. She met the description. She walked between 2 cars, and it wasn't enough just to stop there after they found nothing. They had the right to look around and continue to keep her in custody while they did that.
Yes, given how brief that
now
detention
when we
was.
switch gears to whether or not those questions about the purse, they find the purse, she admits that it's hers. And then we get into the next question, is there anything that I should know about that's in the purse? So now you want to say, well, that's investigatory, even though you used all this other information that they had a good idea she had a gun, to continue the DeBoer analysis and to continue to restrain her. It seems to me a little bit inconsistent.
Well, at
Because
that,
they knew she had a gun.
they did know that she had a gun, Your Honor. They knew that there was a report of a gun.
Yeah, and you want to use that to say that the level of, of restraint was okay, but then you don't want to use it for purposes of analyzing it under Miranda.
Yes, Your Honor, and I don't believe that it is entirely inconsistent because the reason that the officer was continuing to detain the defendant was to further his investigation. into what is going on. Is there a gun? You know, I have this report. He doesn't know that there is a gun.
So
he is
it's consistent.
investigating. I'm sorry, Your Honor?
So in other words, you're saying it's consistent?
I am saying it's consistent. It's consistent with an investigation. As far as, and going a little farther, the defendant doesn't make any admissions at that point. He asks, is there anything in there I need to be concerned about? She says, I don't know.
Officer safety was not an issue below, right?
I don't believe it was ever raised, no. And I don't believe it was raised in my brief either.
Yeah, and abandonment wasn't raised, it wasn't an issue below either, was it? In other words, the idea that, you know, that she abandoned the purse.
I don't believe that was ever raised either, no.
And does that change after she admits it's hers?
I think that
we go back.
Arguably she did abandon it at the time that she placed it on
Well,
the
the court
car.
does mention down below.
No, they don't.
No, it does mention down below a colloquy that it was abandoned, there's a standing issue, but it doesn't seem to go any further. It says the bag, my reading of the records, because at the time Abrams did not know who the bag belonged to, and the defendant has no standing to test any perceived search or opening of the bag at the time of the bag. But it wasn't in the ultimate decision.
Correct.
Okay.
The judge did not base their decision on anything regarding standing.
Thank you.
Unless there are any other questions?
No, thank you.
Thank you.
1298. People v. Smith. Good morning.
Good morning, Your Honors. The lower court erred in summarily denying appellant's motion for a map hearing. Where a property interest or a right to privacy may be unclear, the suppression hearing may provide the court with a factual information.
So tell us what's unclear and why you feel that your client should have gotten a hearing.
I think it's unclear for the same reasons from the same document that was admitted into evidence at the Huntley hearing. Appellant, just as the people, are entitled to rely on the evidence adduced at an earlier hearing, here the Huntley. He did make some unclear statements and he raised some issues that we argue need to be fleshed out, specifically between lines 24 and 30, where my client talks about the Buffalo police arriving at this address. He opens the door. There's nothing about consent. He claims that he was immediately arrested, handcuffed, and put into a police
Yeah, but isn't really this
cruiser.
all about standing? In other words, whether or not, you know, he's got a statement in his motion that says he just met this, the owner of the home that night because it's his friend, the co-defendant's girlfriend, I believe, right?
He does say that,
So
Judge.
it's not like he had any other interest in it. You know, it appears that that is just, on its facts, just, he's a casual guest. He's not an overnight guest, or he doesn't have any real relationship to this place, and therefore there's a standing issue.
There is a standing issue, and that is what the case is about, Judge.
But what would have come out? In other words, what are you relying on that was before the court that would get you to where you need to go, where you at least scratched the surface so a hearing was needed?
The only information that we really can rely on is what came out at the Huntley hearing. And what came out at the Huntley hearing, and that's what the people relied on as well, is my client's signed statement. And even though he does say, and I know where your Honor is relying on, he says, I don't know her at all, I just met her tonight, I went there with Kenny, she's his people's. But he doesn't specifically say, I've never been to that address before. He could have just been evasive.
I guess what the question is being asked by Justice Carney is that in and of itself, is that enough to warrant the court to require that?
Well, I don't know.
That's where it comes in. I mean, you just can't ask for a hearing and have no basis to it. And then when you look at the motion being made and what took place, was that enough in order for the court to order a hearing? And if not, the court has, as you can see, the court doesn't always have to order a hearing based upon. It's just whether or not there's sufficient information before the court that justifies the court to order a hearing. And that's really the core of the argument in your case, correct?
It is, Judge. I agree with that. And you're right. The court does not have to give my client a hearing on a map or a Dunaway issue. It's different standing for a Huntley or a Wade issue. But here we argue that my client does put forth what arguably could be an illegal arrest. It's unclear. Did he step out of the door? Was he arrested first? But for the arrest in this rummaging top to bottom search of this house, there is no contraband. There's no plain view doctrine here. Somebody had to consent.
Thank you.
Thank you, Judge.
Morning.
Morning, Your Honors. It is the defendant's burden to establish standing in the premises searched. He failed to do so here. His moving papers said nothing more than he was a guest at the residence at the time. That's insufficient under this court's decision in Somerville. He did not allege that he had any ties to the residence or he was an overnight guest. And even if the Miranda hearing, Huntley hearing, could have established standing, it made the defendant's ties even more tenuous to the house, where he said he only met the homeowner that evening. So the defendant failed to establish his standing, and the hearing was request for the hearing was properly denied. Thank you.
1229 People v. Gilwiski. Gilwiski. Good morning.
Good morning, Your Honor. May it please the court. This was a simple criminal possession of stolen property case. Did appellant know the property was stolen? Did she possess it? And was its value more than $3,000? The existence of an affair between appellant and her co-defendant was never a material element.
Doesn't that show motive, however? Why, I guess the question, when I was reading this case, why would this woman, at her age, without any prior criminal record, how could she get involved with this? And then, as I continued to read it, it became clear to me. The fact that she was romantically involved with the person who was actually taking the property, it began to make sense to me.
Well, the problem with that is that that isn't an argument that people ever made for entering the Molyneux evidence in the first place.
That's how the court decided it, though, didn't they?
Right, which they really decided it on their own issues rather than the issues that people were raising it. The people raised the issue for a very narrow purpose, to show this problem with the aggravated harassment claims, the false rape allegations. It was never to show motive, and at trial, motive was established by the people, or attempted to be established through a purported gambling problem, which was addressed in the people's case in chief.
Yeah, but the court decided in its decision the issue that we're talking about now, and they talked about motive. It's one of the rationales that the court gave.
Right, but I do believe that is misplaced, because the court never really properly balanced the prejudice that appellant would face from this. There was other evidence at trial to satisfy the material elements of the case, although I still think it's based on shaky proof. There were other things they could have relied on, the financial gain that she was getting from the storage unit. They did discuss in great depth that she had a gambling problem, or a purported gambling problem. But the court...
You dispelled that. I think defense counsel, dispelled that by calling in that witness who apparently was very generous with the defendant and gave her a lot of money to gamble.
Right, and which kind of goes to the ineffective claim. I don't really see the purpose of putting in a witness where there's a problem with motive, or if they're trying to prove motive with another point, that ultimately says, yeah, she had a motive, she had a $10,000 gambling debt to me.
Well, yeah, but in the people's direct case, there was evidence that I think one of the witnesses named Maria, I think, testified that the defendant liked to go to the casino.
Right.
So the jury's thinking, gee, there's a motive, a financial motive here for her to get involved with the stolen property.
Right.
So for you to kind of quiet that down, you called the witness in and said, look, she's my friend. They give her some kind of credits or chips or something that they can gamble with, and I've given her money. We've had a long-standing friendship, so she doesn't really have a financial incentive. I think that's what defense counsel was trying to quiet down.
I can understand that, but the amount of the gambling debt is problematic.
See, here's my concern. You keep on, and maybe I missed it in the record, you keep on referring to it as a gambling debt. As Justice Jones was pointing out, my reading of it was he got these free credits, free checks, and just kept on giving it to the person. Never did he testify, she owes me $10,000, did she? She
said I loaned her $10,000 approximately. I think a loan would imply that
okay,
I'm owed the $10,000 back. But furthermore, the exceptions the court relied upon in admitting this Molyneux evidence, which was truly salacious and immaterial to any material fact at trial, is they relied on the nature of the relationship exception. And that one is problematic for several reasons. Of the cases that address the nature of the relationship exception, those pertain to domestic violence cases, sexual abuse cases, and we could see why that type of testimony would be needed to answer the age-old question, why didn't she leave, why didn't she report?
If the court gave 3 reasons and they were wrong on 2 but right on 1, does that let it come in?
I still don't think so because they didn't properly weigh the prejudice. And the prejudice at the trial is apparent because we have 51 references to this affair and a stolen property case about this affair, which is something the court never even considered. It cursorily addressed the prejudice and just said there's no prejudice. It should have started from the assumption that the Molyneux evidence was inadmissible and carve out exceptions from there, but instead its analysis was it's admissible and here's why, and there's no prejudice.
Let me ask you a question. I just was looking at my notes. My notes reflect that the word wasn't loan, it was given.
I believe the word loan was used at a different portion of the trial. But if that's Your Honor's understanding, I will stand corrected.
We'll take a look at it.
Thank you.
In page 578, that she had given her approximately $10,000 over the time they've been friends. That's why I just asked that question.
Right.
Because I don't recall seeing her, but we'll check on it.
Okay.
That's kind of important. Okay, anything else?
Well, just briefly on the narrative and the interwoven use exception. That's to show when there's multiple crimes perpetrated in quick succession, like we see in Gines. And that's another case that the court relied on in admitting this Molyneux evidence. It's also pertinent for identity issues. None of the matters in that specific exception are applicable to the case at hand. Ultimately, the point I want to get across is the people had other evidence they could have used to show the material elements in the case. This wasn't probative to whether she knew it was stolen or not. And so for that, I would ask for reversal. And unless there's any other questions from the court, I'll submit on the remaining questions. Thank you.
Good morning.
Morning. If it please the court, the court did specifically hold that this went to motive, and it did explain why a person like this would get involved, and it did not cause prejudice because the defense would have raised it. Her whole theory of I was taken advantage of, I was duped, would only work if she showed this relationship. And it's obvious when defense counsel did not move to redact friends with benefits from her statement that he intended to use this himself. The evidence of gambling, there was no argument there was a problem. Gambling came across as a social activity that these two did. The people's witness didn't call it a problem, and the defense clearly wanted to create the impression I'm willing to pay for her to join me gambling, and rather than go to dinner or movies or the theater, I pay for this. Thank you.
Thank you. 1300 People v. Rookard. Morning.
Good morning, Your Honors. May it please the court. The people did not prove beyond a reasonable doubt that appellant had constructive possession of this cocaine that was found on top of the refrigerator in the kitchen. He did not exercise dominion and control over this evidence, and his mere presence in the apartment does not establish constructive possession of this
Was the room presumption part of this analysis?
I'm sorry?
Was the room presumption part of this analysis?
Yeah, there was testimony from an officer that they located him when they barged in. It was a no-knock search warrant.
He was in the kitchen where the drugs were found?
That's correct. The officer, Brian, was the first one who entered, said he was in the kitchen. Appellant testified on his behalf, saying he was just lying on the couch with his son. He was there to drop off the child. It was his ex-girlfriend's apartment. He was only there to drop off the child. There was conflicting testimony between Officer O'Brien and appellant. Contrary to what the people say in the brief, appellant provided consistent and plausible testimony that
it's a credibility issue by the court.
Yes, it is a credibility issue.
And really what it boils down to is whether or not there's sufficient dominion and control over that room that he was in that would give rise to the possession area and the use of section, was it 220, 25 with the room presumption?
That's correct, Your Honor. There was also a gun found in the bedroom. The court did not find constructive possession of the gun found in the bedroom. Then there was conflicting testimony between the officer.
The court indicated that they found some of his testimony credible and some of his testimony non-credible.
Correct. And also in respect to the Miranda issue, it's unquestionable that the issue of Child Protective Services getting involved had a direct impact on whether appellant made statements, incriminating statements. It was Officer O'Brien admitted that the question of CPS, Child Protective Services, was mentioned There was definitely an issue whether this child was going to be taken away. This obviously coerced and manipulated appellant to make an incriminating statement.
Wasn't there some testimony that he didn't know whether or not the defendant had overheard that conversation?
Oh, well, Officer O'Brien testified that he did overhear. They were both in the living room at the time, and the overheard.
He did. He didn't know whether or not the defendant had.
Well, I'm sure if Officer O'Brien overheard it.
Just asking if that's what he testified.
Probably. He didn't testify. I'm not positive he testified about that. But obviously, if Officer O'Brien overheard it, I'm sure the appellant overheard the discussion of bringing CPS involved.
Okay,
thank you.
Good morning.
Good morning, Your Honors. With all due respect to my opponent, this is not a case where the defendant was merely present in a house where a search warrant was executed. The evidence established that the defendant knowingly and unlawfully possessed the cocaine and that he had dominion and control over the residence where it was recovered. As Your Honor pointed out, the defendant was in the kitchen when the police entered the home, and that's where the cocaine was found on top of the refrigerator. There was also a scale and a razor and a plate out on the kitchen table where defendant had been. The defendant had a key to 279 Rother in his pocket. There was mail addressed to the defendant at that address inside the residence. There was adult male clothing in the house.
But you have to admit, though, regarding all those factors, the defendant did explain them away. So it really would have boiled down to he gave a reason why he had the key, why the mail was there, why he was there, and really would have boiled down to was whether or not the court believed him and the court didn't believe him. The court indicated they believed him on some of it, regarding the gun, which is the most serious offense, as opposed to the drugs, which the court didn't believe him.
Exactly, and I think that goes right to the weight, which was another argument my opponent made, that the court properly credited testimony of the police officers on most of the allegations, but they also did consider what the defendant said, and I think that when they gave their verdict, finding him guilty of the possession of the drugs and not guilty on the gun, it showed that they properly weighed the evidence in this case. And just moving on to the Miranda issue, or the statements regarding the Child Protective Services. The conversation that the police officers had regarding Child Protective Services took place in a different room outside the presence of defendant. And there was no evidence whether defendant actually heard this conversation or not.
I think what counsel is arguing, though, if the officer heard it and the defendant is right next to him, the defendant must have heard it. That's what he's...
And even if defendant heard it, this conversation is perfectly appropriate under the circumstances.
Yeah, it wasn't the conversation was really, what are we going to do?
Exactly.
Not,
there was a 3-year-old child in the house with an illegal gun and illegal drugs. The officers are mandated reporters. They have to call Child Protective Services under these circumstances. So it's perfectly reasonable, and there's no evidence that this was used as a threat to induce a confession from the defendant.
His version.
Right.
Sure. Okay, thank you.
Thank you.
1302 Guido v. County of Cayuga. Good morning.
You got me surrounded.
Not yet.
They've got me surrounded.
Not yet. It's okay. He was looking for some help.
Pardon me? May it please the court, John Sereno, on behalf of the appellant, the Guidos. This is an appeal from an order vacating the note of issue and certificate of readiness and striking the case from the trial calendar, and also denying our motion to sever the third-party action. I know the court is well familiar with the fact this is one of those Cayuga County cases where the defendant, or the plaintiff, is required to take benzo for medical purposes, and the jail has a policy that they don't give it. The note of issue was filed in 2015.
Third-party action was then commenced in April of 2016, and the motion to vacate was made about, what, 6 weeks later?
Yeah. And it's our position that there was an undue delay in commencing the third-party action in this case. And when you look at the allegations of the complaint is because of what happened in the jail.
Yeah, the first party action is the denial of meds is really the core of it. The third party action is a misinterpretation of a med mail based upon a CT or an MRI.
Yeah, which, with all due respect, has nothing to do with the underlying cause of the action.
Well,
their policy.
They do both relate to what the origin and the cause of the plaintiff's damages are. They are different theories. You're absolutely right, but it seems that there is some commonality between the main action and the third-party action, and that's really the question.
Well, then I think you have to look at the delay. If you're correct, you have to look at the delay in commencing the third-party action when the case is trial ordered. And it's I think I'm correct that if there is a relation between our claim and the third-party claim such that we could use that claim, we now can't sue them directly. So I think the delay really prejudiced us. I mean, they're still going through.
But once again, where's the prejudice of the delay? I know you talk about there may be a larger lien.
Well, the lien, and I think what happens is when you look at the lien, so much, you're going to hopefully recover so much money. From this point back is to pay the lien. This point forward is to pay for his future care, and at this time, he's entitled to probably a Cadillac, okay? As we're moving forward, okay, the payback has to increase.
Well, that's
so that the forward part is less.
But the past damages then would be greater. I mean, really, when you just move the trial forward, you're just changing, you're just moving the damages in the timeline.
But in this is a unique case because those timeline back is paying back a lien, a very large lien. And
he will need less to take care of himself in the future because the future's shorter now.
Well, they hope that the future is very short.
Well,
the way they're pushing this,
he's only got so many days. We all only have so many days.
The way they keep pushing this out, but you also have the cost to the plaintiff of additional discovery. The biggest thing, I think, is the fact that the second part, that the plaintiff tactically and for very good reason did not request a jury trial. Okay. Now the third party, one of them says, well, we may request a jury trial. So it's our.
You're saying that you're prejudiced because it interferes with your strategy.
Right. And we talked about the, it's my understanding now that the county is indicating that they have a very bad financial situation. And I think if you put that in front of a jury and say that we have a very bad financial situation, that it's going to negatively impact. And I think the financial aspect of it is really
that would assume,
prejudicial.
Yeah, that would assume that a court would allow that evidence to be presented to a jury. The state of the county's fisc.
How about an article in the newspaper?
Well, there's always articles, Counselor.
I know, just because the ball scores are correct.
You charge a jury to disregard that. So.
I know.
Anything else?
Yes, insofar as the note of issue is concerned, I think that the request to strike it was totally outside any time frame allowed in the statute, and we've shown the financial and the tactical prejudice, and the note of issue can be held in abeyance, or even the motion to dismiss could be held in abeyance, and we would, if the court doesn't agree with us in the first part, we would request that it at least be held in abeyance, or the motion itself be held in abeyance. And other than that, thank you.
Thank you, Counsel. Okay, I have Spagnoli, Emery, it doesn't matter to us. I mean, just let us know who you represent.
Your Honor, I represent the defendants. Since it wasn't our motion below, I assume the court would want to hear from the movement, but I'm happy to speak now. This is not a case in which the plaintiff claims the defendant committed one act of misconduct, caused him an injury, and then was no longer involved, and then the plaintiff went to the hospital and possibly suffered aggravation of his injuries. In this case, the plaintiffs broadly claimed that over a 2-month period of incarceration, the defendants were guilty of any number of acts of supposed negligence or malpractice. During those 2 months, the county and the jail sent Mr. Guido to third-party defendant Auburn Hospital 3 times. He was scanned in his head 3 times, and the third-party defendant radiologist interpreted those scans. It is defendant's contention that if there is malpractice in this case, it was the malpractice of the third-party defendants that caused.
You may be right there, but I read this. Where have you been?
I'm sorry?
Where have you been? This case was pending for 3 years.
I appreciate that, Your Honor. First of all, I first came on the case in October of 2015.
You understand the frustration here on how this is getting dragged out?
I do.
You were there for 3 years. You had a decent third-party action, and you waited all this time to bring it.
We didn't know that, and the reason we didn't know that is we don't take each individual batch of medical records, give them to an expert, and have him give a report, and then get another batch of medical records and get another report. We wait until we have all of the significant records, provide them to the expert in one batch, and get one report. In this case, Strong Hospital, which was the entity that treated Mr. Guido after his final crisis in March of 2012, we didn't have those records. So it wasn't until we had those records that we provided the records to the expert and got a report in which the expert, during the course of which the expert said, hey, there's something wrong with the reports on these scans. You need to look into this. I believe that there's malpractice on the part of these radiologists. That, Your Honor, is the reason for the delay in bringing the third-party action. But again, not only do we contend that the third-party defendants contributed to the malpractice, but the information or the lack of information or the incorrect information coming back from them during the 2-month period informed and affected my client's actions. So there is no possibility of holding a trial upon plaintiff's claims without addressing all of the factual issues underlying the claims in the third-party action.
Where does the discovery in the third-party action stand now?
Currently, Your Honor, basically the written discovery is done. We've been attempting to expeditiously conduct depositions, but plaintiff's counsel basically resisted providing us details as to his availability. It led to motion practice. We now finally have dates when he's available. We've been able to conduct 1 deposition, and we have deposition dates in possibly November, contingent on his trial schedule, and then otherwise in January. So we're moving ahead as quickly as we can, and it has required us to bring some motion practice. In addition, if there were a separate trial of the claims by the plaintiffs against the defendants, there would have to be an apportionment of liability among the third-party defendants because of, at a minimum, CPLR Article 16, which requires those calculations to be done in order to determine the defendant's liability for non-economic damages. So if there had been a severance, the following things would have been resolved in the trial without the third-party defendant's presence. 1, whether the third-party defendants contributed to Mr. Guido's injuries. 2, the full value of his injuries. And 3, the full apportionment of his injuries, including the percentages to be borne by the third-party defendants. All in a trial where third-party defendants had been granted not full pretrial discovery, but also had been denied even the opportunity to participate and attend. Under these circumstances, Your Honor, I can't imagine a more severe form of prejudice, and certainly the trial court's denial of severance cannot be construed as an abuse of discretion. Under those circumstances, since there has to be a unitary trial of all the claims, the third-party defendant's rights to a jury trial prevails over the plaintiff's, respectively, strategic desire to have a bench trial instead. I'd be happy to address the Medicaid lien issue if Your Honor.
Thank you.
Thank you.
Good morning.
Good morning, Your Honor. Ryan Emery on behalf of respondent third-party defendant Dr. Philip Gottlieb. As the court may know, Dr. Gottlieb is the one who brought this underlying motion to vacate the trial note of issue and certificate of readiness that's now on appeal here. I see the court has a very full calendar. You've heard from a respondent for the County of Cayuga, so I'm going to try to be very brief here. I would submit to this court that this appeal is not really about whether the lower court properly vacated the trial note of issue or not. I appreciate that Appellate's counsel had briefed that issue, but if you look, Plaintiff's counsel, who Appellate's counsel works for, had essentially said in the court below that it would have been unfair for Dr. Gottlieb and the other third-party defendants to have to go forward with that trial, and that's on page 150 of the record. And certainly it's not Dr. Gottlieb's fault that he was brought in, months before this trial was supposed to start and mere days before a pretrial conference was scheduled in this matter. So what I would submit to this court, that what this appeal is really about is Appellant's cross motion to sever the third-party defendants from the main action. That's really what this appeal is about, I would submit to this court. Now, if we look at that issue, and again, I think respondent for the County of Cayuga has already addressed some of this, so I'll go through it very quickly. Certainly, if you look at judicial economy, by not severing, we're only going to have one trial. By severing, we're possibly going to have two trials. So judicial economy would seem to dictate it would be better to not sever it and just have one trial to decide all these issues than possibly having two if appellants prevail at the main trial. Certainly, Dr. Gottlieb is prejudiced if it's not severed. He can't participate in the trial. He's got affirmative defenses as against appellants. He can't pursue those because he's not part of the main trial if it's severed. We're basically stuck with whatever the jury decides the amount is, and then the second hypothetical trial is figuring out how to apportion that. That's not fair to Dr. Gottlieb at all. So let me just end with this. The question that we're now faced with is, have plaintiffs proved their burden that they're prejudiced somehow by not severing the case? I've read appellant's brief. I've read their reply brief. I've heard oral argument. I still do not understand how a Medicaid lien prejudices them. I don't understand it at all. If you have a Medicaid lien, it doesn't just magically increase out of its own. It increases because you have medical costs. And medical costs are a special line item damage on a verdict sheet.
We understand that. Might be to his benefit. He settled the case.
I mean, well, certainly it's possible that
pay less.
That's certainly possible, but if the Medicaid lien has increased because we didn't have a trial back in when it was supposed to, as opposed to now, you factor it into settlement. You can actually go to Medicaid and say, hey, we're trying to settle this case.
We understand that.
So let's negotiate something. And lastly, Your Honors, I would say as to the bench trial, I mean, there is no fundamental right to a bench trial. There's a fundamental right to a jury trial. There is no fundamental right to a bench trial.
We have that.
So with that, Your Honors, unless you have any further questions, respondent, Dr. Gottlieb, respectfully requests that the lower court order be affirmed, and I thank the court for its time today.
Thank you. Good morning.
Good morning. James Egan for Auburn Community Hospital. When I was first retained to represent the hospital in this matter, we were informed, I think we were sued, and then a couple months later we were informed there was a trial coming up in a couple of months. We took immediate action to protect our clients' interests. There was no way we could be prepared for a trial of this magnitude in that short a period of time. As Justice Peredato pointed out, we have since been afforded an opportunity to conduct discovery that is moving forward. I think in that sense, this motion and appeal are somewhat moot, and there's not a whole lot to resolve because the case has progressed. We have had an opportunity to conduct discovery.
Thank you. 1303 Phillips v. Buffalo Heart Group. Good morning.
Good morning, Your Honor. May it please the court. I guess in terms of my first point that I put out in my brief is that the defendants failed to meet their burden in this particular motion to dismiss. And I guess I'll start with the first point of their whole basis of why they claim that the case should be dismissed is purely on the issue of prescription, which I will address in a second. As I pointed out in our papers, and it's very clear in the bill of particulars, the allegations go beyond the mere issue of prescription, go into their whole treatment, evaluation, and following of my client.
In other words, your theory is that on the day that it was prescribed, that can't possibly be the accrual date because this went on, this prescription went on during office visits, it was discussed or not discussed, but it was in the chart that it was continually prescribed, and that this was an effect, although he was being treated for cardiac problems, the fact that these prescriptions cause the injury, and that being this bleed.
That's correct.
Okay. And so that gets you out of the first day of prescription, okay, if we didn't count that date. Do you want to be heard on the continuous treatment issue?
Well, I do, Your Honor, to the extent of the issue of prescription in this particular case. Counsel relies on a very specific case pattern, which was, thoroughly contemplated before this court. That was a full summary judgment case where you'd had complete discovery.
And the whole case wasn't dismissed either.
Right, exactly. The whole case was not dismissed. And it was just purely the issue of prescription and when accrual occurred with regard to that particular issue based upon the drug at issue, which was an estrogen cream. And I think, based upon that case and the type of drug that it was, it appears that some of that was hand in hand with both the liability and the causation, because with an estrogen cream case and that particular issue that seemed to be put forth by the plaintiffs and their theories of liability and causation, this was something that from the beginning there was a contraindication and it was causing this plaintiff harm over time. This was a continuing type of injury that was going on with that particular plaintiff. This particular drug is a totally different type of medication. We're talking about an anticoagulant, not something that necessarily is a slow, like that particular case where we're talking about breast cancer, which may be developing over time. With an anticoagulant medication, somebody could have an immediate reaction. You could be fine one day on that medication, not fine the next, based upon the particular circumstances. And all you need to do is look at the label of this particular medication to know that.
Okay, let me ask you this. They argue that the last date, as I understand it, that it was prescribed was December of 2012. And then in essence, they argue that even if we use that date, that would require the complaint to be filed by June of 15. And this complaint was filed, someone's complaint was filed in July. Can you address that for us?
I can, Your Honor, and I think that goes to the distinction between in this particular type of medication. I don't think it follows that in every single prescription case you can go from the first date of prescription or the last date of prescription. I mean, sometimes people are on medications for 10, 15, 20 years. And the issue of prescription doesn't necessarily go to writing the piece of the prescription itself on a piece of paper now in the computer. It may go to other issues that the provider may or may not be aware of on that day and continuing, such as do things come out after a prescription is made, such as a notice from the FDA regarding certain additional things they need to be taken into consideration in the prescribing the medication? Are there label changes? And in this particular case, is there some type of change in the medical condition of the plaintiff?
Well, let me ask you this. Did the plaintiff continue to take the drug?
Yes.
And just the December date was that was the last prescription, but he was prescribed this drug for the future.
Correct.
And continued to be treated by this physician.
Correct. And he had an appointment going into June. I mean, this was an ongoing thing that he was provided medications by this practice and this particular medication for some period of time, and he had another appointment to come back in June as a continuation of his course of treatment for his atrial fibrillation, which includes...
If we follow your theory here, okay, does that require us to overturn or disavow patent?
Well, Your Honor, I think in terms of my take and my look in patent would be, I think that's specific to that medication and the court's connection between the accrual date and the liability issues and the causation of that particular medication. I don't think that general position of patent holds true to every prescription medication.
And is that because of your argument that in patent it was a slow buildup, so to speak, and that in this case, each and every day is a new day. In other words, the risks that are associated with the prescribing of these drugs, it could cause this injury immediately.
I would say that is correct, Your Honor. I think every prescription medication case has to be taken on its own individual basis in terms of the liability and causation issues involved. Not every drug is the same, and they're attempting to paint a broad brush over every single prescription medication and say, if it's a prescription, well, it goes from day one. Well, that, again, isn't logically true. And in terms of what I just pointed out, people are on medications for years, and they might not have issues, or the liability or the malpractice might not occur until years later because of different issues. Again, changes in the person's condition, changes in the labeling, changes in all of these things that really are hand in hand with the liability issues involved.
Does it make a difference that there were two different physicians involved in Patton and it's just the same one physician in this case?
I don't think so, Your Honor. I just think that...
does that get Patton out? Does that help you?
Well, it may, but I think it goes to, again, the particular drug at issue, you know. And I think you have to look at each case individually when you're talking about prescription medication. One prescription medication is not the same as another and does not have the same liability and causation concerns.
Okay. I think we have your argument.
Okay. And can I address the rest of it, Your Honor?
Oh, sure. Go ahead.
The only other point I want to make is I think what Judge Carney pointed out was, the defendant's whole case was on purely the prescribing of the medication.
They buttonholed it down below, strictly a prescription case.
Strictly a prescription case, and they kind of, everything else was taken out, even though there was more claims.
Into the patent case.
Right.
We have that.
Okay. Thank you, Your Honor.
Good morning.
Good morning. I think that, as Justice Carney was sort of alluding to, whether or not we follow the majority opinion in Patton and say that this case, statute of limitations began on the first day the drug was prescribed, or if we follow the dissenting opinion in Patton, which said that it was the last day, essentially, that the plaintiff was seen, this case is time barred. Whether it is the last day that Dr. Jennings ever saw this patient, which was in December of 2012, or the first day he prescribes the drug, this case is simply too late. And
but there was another appointment, and that's where we get into the continuous treatment.
There was one more appointment.
We've got a couple moving targets. In other words, you want us to adopt the rule initially that the first date that it's prescribed is the date that gets the clock ticking.
I would, yes.
Even if we don't, if we said, okay, we don't agree with you there, your position is the last day that he prescribed the blood thinner, and the last day that he saw him was in December?
It's December 14th, 2012.
And that would get you to, so your position is that at that point, the statute was run in June, and this was commenced roughly a month thereafter.
Yes.
And it would be time barred regardless.
Yes, that is my argument.
There was a consultation, wasn't there, on January 2?
There was a consultation on the 2nd of January. It was not by Dr. Jennings. It was by a PA at Buffalo Heart Group. And as the plaintiff agreed with in her underlying papers, nothing was discussed about this drug that she's claiming was, whether or not you want to say it's negligently prescribed or negligently followed.
But it was a consultation for his heart condition, wasn't it? And that's really what he's treating with this heart group for a heart condition, and the prescription of the drug is part of that treatment.
The consultation was for shortness of breath. He comes in because he's complaining of shortness of breath.
Pretty common complaint for a heart
patient.
Very
common complaint. And there's no claim that the shortness of breath should have alerted the provider to stop ordering the Pradaxa. And in any event, if that was the claim, I think that an argument that continuing to fail to notice something or recognize a complication is not continuous treatment. And those are addressed in my brief.
That's not the point. Their argument is it's an affirmative act of negligence. In other words, just because they didn't treat the bleed is not the end of the inquiry. Their point is the drugs were prescribed to treat a condition separate and apart from the bleed, but that relationship and that prescribing caused an injury, a side effect related to treating the cardiac condition. And therefore, it's not a failure to diagnose, it's a affirmative act of negligence, And I think their point is that in September, or in December, the point that you pick is the last date that they were seen. They were continuing to be seen even in January. And although there wasn't a new prescription, the prescription was ongoing. And when the doctor, the cardiac doctor or the physician assistant out of that office looked at the chart, of course they have to each and every time analyze and consider the side effects that these drugs cause.
And their argument is that the side effect that this drug caused was essentially a GI bleed. Now, he doesn't come back to Buffalo Heart Group on the second for a GI bleed. It's for shortness of breath.
Well, let me just pick up on that point. The difference between this case and, for example, Patton and the failure to diagnose cases is, in those cases, the damage has occurred. In this case, the damage didn't occur until there was a bleed. Isn't that the time when the statute of limitations should start to run, when all of the elements for the cause of action are in place?
Not pursuant to, if we follow Patton, I would say that the law says that that is not the way the continuous treatment doctrine is applied.
But the problem with Patton is the damages were there. The plaintiff had sustained damages back at the time that we said the statute started to run. Here, the plaintiff didn't sustain any damages until there was a bleed.
And if we were to apply the statute of limitations to say that it begins to run when a damage begins to start, then perhaps I would agree with you. But because the statute of limitations is supposed to run as of the act of negligence, that does not continue it.
Yeah, let me ask you this. I wrote down, something that Patton stands for, and I think this is, you're not going to like how I phrase this, but this is how I see your argument. A doctor can prescribe a contraindicated drug that should be actively and closely monitored. That's their position. For a known side effect. The drug causes the precise side effect, and then the doctor can walk away from the harm he or she caused because he or she didn't recognize and or treat the side effect, and only continue to treat the condition for which he or she prescribed the contraindicated drug. That doesn't seem to be a good rule. That's their position. Their position is that it's a prescribing case that it shouldn't have, and you've got to monitor it, and then ultimately, I think the point that Justice Peridotto brought up, ultimately the injury took place with this bleed, and it doesn't matter if they weren't treating him for the bleed. They were treating him for something that caused the bleed.
And there's no claim in the Bill of Particulars that something was missed or that something changed that should have alerted them to stop this drug.
Your point about that when they came in with the shortness of breath, there wasn't their claim as it related to that, and that's probably consistent with the bleed. Is that your point?
Yes, that's my point, yes. All right, are there any other questions?
Thank you, Counsel.
Thank you.
1304, Sansbury v. Brzezinski. Good morning.
Good morning, Your Honors. May it please the Court. The issue here is whether there is any rational view of the evidence which supports the finding that the defendant driver in this case was not negligent. And the answer is no, because the uncontroverted evidence was that, first of all, this defendant driver had a stop sign, had the stop sign. The plaintiff on the bicycle had no stop sign. So he was required to yield the right of way, and he did not.
Well, all right, let me just interrupt. There was, the way I understand it, the photos are actually very helpful, the photos that were in evidence. There was testimony that the defendant stopped at this stop sign, which is set back. I don't know, you know the intersection better than I do, but according to the photos, it looks like it's set back 1.5 to 2 car lengths from the roadway. So there was proof from the defendant and from this witness, who I believe was behind the defendant, that the defendant stopped and then started to pull forward. So and then there's the collision between the defendant and the bicyclist. So what we have to look at is whether there's any evidence to support the jury's verdict. And I'm wondering why the jury couldn't conclude that the defendant did stop, and so therefore didn't violate that section of the vehicle and traffic law, and then inched forward when it was before the bicyclist was in the intersection and before, and at a time when it was safe to do so. Let me just look at that. So that's when it was not, when the inch forward at a time when the, before the bicyclist was in the crosswalk and before the bicyclist was close to the crosswalk, so that at the time it was safe to do so.
And that the vehicle was, the defendant was in the right-of-way at that point because of everything that Justice Perdomo said.
I think then we have to look at the vehicle and traffic section and how it pertains to this specific intersection. And as you said, Your Honor, the stop sign is well back from the sidewalk. Okay, what we have here is a crosswalk. If you look at, I believe it's 1172, it's in our brief.
Right.
It defines a crosswalk. Actually, this is an unmarked crosswalk because you don't have the lines.
Right.
So with that setup, he is required to come up to the crosswalk and stop.
Again.
And stop again and look both ways. Okay. And
he was moving when this collision occurred.
Absolutely, Your Honor. And that's uncontroverted. He's moving, and it's also uncontroverted that he's actually in the crosswalk at the point of the impact. So he's past the stop sign, he's moving, he's in the crosswalk, and I would add, he has an obligation to see what was there to be seen. This bicycle was clearly in view at all times. He had an unobstructed view, and yet he admits he never saw her.
Yeah, but Counselor, as we go through step by step, it appears that he inched his way up, little by little. It appears from the record, could you not conclude that he stopped before the sidewalk, then he inched forward while he was in the right-of-way. At that point, the collision took place. The witness behind the car says she never saw the bicyclist until the impact. And of course, your client says she saw him, she stopped, she waited, she got the wave, and it was all in front of the jury. So could the jury not have concluded that he took the necessary steps to not violate the vehicle and traffic law? I mean, that's really what we're looking here. And in fairness to you, you started out with, and it's true, is whether or not, upon a fair interpretation of the evidence, the defendant was negligent. And so we have to look at not what your client said particularly, what the jury could have gleaned from the testimony that was there, pick and choose what they like to, and believe what they like to reach this conclusion.
I understand that, Your Honor, but I'm saying based on the uncontroverted evidence, which again is
fair enough,
that he's moving, he's in the crosswalk, and that he never saw her.
So let's assume that because I've read this over and over, I'll tell you, this is a tough one factually. So let's assume he, under the V&T law, he's supposed to stop at the stop sign, he does it, then he goes forward, he's supposed to stop again. He does, and when he stops, and that's the way the proof came in, right, and then he continues. When he stops, he doesn't see anything. And now he's inching forward, right?
Your Honor, I believe there's only one stop. There's only proof of one stop.
Okay, so he never stops after the stop sign.
Right.
And your point is the fact that he didn't stop when he came up to where the crosswalk, undesignated crosswalk was, that necessarily makes a violation of, the V&T.
That's right.
And that he couldn't be in the right-of-way, and she must have been in the right-of-way.
Again, because he has the stop sign and she does not.
Right.
He has the duty to yield, she does not.
Yeah, was there any proof that came in relative to, and I don't mean this from a perspective of her comparative negligence, but just from a perspective from what we're talking about now, whether or not she was traveling in the right direction, was where she was supposed to be, whether to be in the road or on the sidewalk. In other words, trying to make some determination. Did the jury have some proof to make some determination whether or not the bicyclist was in the right of way?
Yeah, absolutely, Your Honor. Based on that road, the conditions in that road and the local statutes.
She testified about that.
She was within her rights to be on the sidewalk at that time and place.
Because she said the other side where I think she's supposed to be, right? She's supposed to be traveling.
There was no sidewalk on the other side. In fact, it was a very hazardous situation. There were deep holes.
So that's why she was on this side.
Absolutely.
No shoulder, no bike lane in a very busy highway.
Exactly. We have some photographs that show those conditions. So she was completely within the law to be proceeding down the sidewalk. And
isn't the focus here on his negligence, not really on anything she did?
Absolutely, Your Honor. And I think we need to keep in mind that that's the only issue. Is it proper to find that this defendant was zero negligent? I mean, we're saying that.
No, we understand that. And my questions weren't focused at commingling or you know, confusing those two, conflating those two issues.
Okay.
My question was just from a perspective of, you know, when you deal with failure to yield the right of way, I think it's necessary to understand if the, you know, who's in the right of way.
Yes.
You know, to determine whether or not his violation of, if he did violate the VNT.
To have the whole picture.
Right.
Yes.
Yep.
Absolutely. And then I would just add that since he was negligent as a matter of law here, based on the uncontroverted evidence, the plaintiff should be entitled to a directed verdict just on that issue, just on defendant's negligence.
Then we go back to the causation issue.
So when we go back, we don't risk this happening again. We have a very sympathetic defendant here. I think that was part of the problem. He's an older gentleman. He came in a wheelchair. That was part of the mix here, I think.
Thank you, Counsel.
Thank you.
Good morning.
Good morning, Your Honor.
Also, could I ask you there's a couple of uncontroverted facts here. Your client had a stop sign.
Yes, Your Honor.
Your client was moving forward when the collision occurred. And the collision occurred along the front of your client's car, a little front bumper.
That's correct.
Not the doors, not the rear fender, but along the front.
That's correct.
In the crosswalk.
The crosswalk is unmarked, but yes.
Yes, but in the crosswalk.
Yes.
So those facts are uncontroverted. Is that not correct?
Yes, according with the non-party witness and everything. My client was not able to clearly identify in the photographs, but yes, the non-party witness laid out that evidence for the jury at the trial.
Okay, so there's a stop sign. Your man he had the stop sign, he's moving, and there's a collision with the plaintiff.
Correct, Your Honor, and the way...
Did he fail to yield right away?
Your Honor, we don't believe that he did. Another piece of uncontroverted evidence is that he did stop, and if Your Honors have with the record on appeal on page 229, it gives a really nice picture of what the plaintiff and the defendant were working with. The stop sign is, Your Honor had pointed out, set far back.
Wait, no question.
So he had to stop and then inch for it. To the immediate right is a set of trees, which is evident from page 229 of the record. So as he's inching forward, it's not uncontroverted that the bicycle was in plain view.
Well, he didn't ask that the court charge that there was an excuse here. You know, we talk about an unexcused violation of the VNT. Right. He didn't ask for that. The charge was just, did he violate a vehicle and traffic law? And if so, that's negligence. That's the law of the case here.
Correct. And section 1172 requires that a vehicle stop at the stop sign and yield and get to a point where he can reasonably see the oncoming traffic. In order to do that, because of this intersection in the trees, he would have had to have inched forward past that stop sign.
I understand that, but you can't go forward if someone's coming. You
Correct.
have to stop, but you can't go until the coast is clear.
Correct, Your Honor. And that brings me to make another point, is that the plaintiff has the burden to prove the negligence. The plaintiff presented two separate theories of negligence to this jury, thereby giving them the opportunity to assess the issues of credibility. The plaintiff herself, as Your Honors all noted, said that she stopped and was waved by my client, and then he backed up. The non-party witness said that's impossible because I was bumper to bumper with him. So then you have that theory of negligence being presented to
So on this record, you could reasonably, the jury could have adopted that.
Correct. But then you had Mr. Campbell throughout the case, especially when he was cross-examining my client, really focusing on that she was in the view and that she never stopped. They were presenting two separate theories of negligence to this jury. And
so that would be, the argument would be that he should have stopped again at the crosswalk because she constituted an immediate hazard under 1142, and that's the negligence they were arguing.
Correct. But they had to take a piece of the plaintiff's and a piece of the plaintiff's counsel's theory in order to get to the negligence. They were taking a piece of both to get to this negligence, and the jury was there assessing the credibility. And the jury had, unlike the cases that are cited by the plaintiff, the jury had a non-party witness that said clear as day, the plaintiff, the bicycle hit the vehicle.
Well,
she said that multiple times.
Yeah, there's a collision.
Correct.
And it's along the front of the car. I could see the bicycle hitting the vehicle if the bicycle, you could classify it that way, if the bicycle hit, say, the side of the car. It's happening in the front.
Correct.
And she's going straight across the crosswalk, and it happens in the front of the car. And he's moving forward. Even the non-party witness said he's moving forward into the crosswalk where the bicyclist is.
And the non-party witness said she came clear as day from the right, out of nowhere, and struck the vehicle. If the vehicle is, even if that vehicle is inching forward, if the plaintiff faltered in any way and moved her bicycle, steered it just a little bit one way or the other, and if she's traveling not in a direct, exact, straight path, that could have happened.
It's in the crosswalk.
Well, correct. But according to her, she had stopped and was waved by. So the jury was free to assess that credibility and say, no, the defendant didn't do anything wrong. The plaintiff could not prove, which is her burden, that the defendant was negligent by having to present two theories of evidence to get to the negligence. I'm sorry, 2 theories of negligence. I'm sorry.
Okay, thank you.
Thank you, Your Honors.
1305, Moreland v. Huck. Good morning.
Good morning, Your Honors. Jennifer Friedman for Appellate Joanne Moreland. This case involves a managing member of an LLC who, through self-dealing, forced the ouster of a 20% minority member for significantly less than fair market value. The lower court erred by resolving disputed questions of fact and erred by finding the exculpatory provision of the operating agreement enforceable and also finding that the drag-along provision of the operating agreement excused respondents' actions. I'd like to start briefly with the drag-along provision. Even if the drag-along amendment was properly added to the operating agreement, that does not excuse the respondent's bad faith, breach of fiduciary duty, or failure.
Let me ask you this. Do you think that what's a Court of Appeals case, the Alpert case, is applicable here?
Yes, Your Honor.
Okay, so do you get there as a plaintiff, even if you can't prove that, in other words, there was a bona fide business purpose, assuming there was. Do you get there even if that's the case because, as one of your arguments, the fiduciary duty was violated because a fair market value for her interest in the membership was not
yes,
given?
Your Honor.
So you don't even have to, even if it is a bona fide business purpose, there's still a fiduciary duty, even under 417, it rolls
yes.
to rises to a higher level.
Yes, Your Honor.
But she's got to be given a value.
Yes, Your Honor.
So alternatively, and I'm going to let you get into your first argument, but that's been bothering me, is whether or not that was a part of your theory.
Yes, Your Honor, absolutely, because, of course we dispute whether there was a bona fide corporate purpose at all, and it was respondents' burden to prove that because of the self-dealing issues. And we think that there are a lot of questions of fact regarding that.
Well, I think their theory is, their position rather, as I see it, is just basically, look at the whole purpose of this from the beginning was to have people that were interested, in other words, doctors that were going to also be tenants, and the only reason this took place, that the plaintiff was given any interest in the membership, was because of Dr. Moreland, and then when there was marital problems, that no longer existed, and therefore the purpose. This is a legitimate purpose because what we're going to do is, we had expiring leases, and we're going to just reshuffle the deck to get back where what we intended to do from day one.
I appreciate the respondents' arguments. I have a couple responses to that. One is, that's a PLLC, Your Honor. If they wanted to have that kind of a corporation where the professionals had to hold the membership interest, they should have formed that. They did not. And also, respectfully, even though they're spouses, they are separate legal entities, Your Honor.
Right.
If they wanted the doctors to hold, the spouse is not the doctor. They are separate people.
Yeah, I agree that they could have created it differently, but when you look at Alpert and where those individuals were frozen out, and they looked at, once again, lack of a better word, the business judgment, business rule, you seem to be arguing from the beginning, first of all, it's a sham.
Yes, Your Honor.
And bad faith. And then I look and I see you didn't depose Dr. Moreland, you didn't depose any of the other people, is that correct?
That's correct, Your Honor.
So now what we're stuck with is, in my view, to a certain extent, is Hawk's interpretation of what they need to do for this corporation to, or this business to survive, and he calls upon other people in the field, was it Largo Real Estate, some other Mr. Phillips or whatever, to get their take on what's going on, and then ultimately makes a decision. So in my view, we have to find that that decision that he did was flawed.
Right. Well, Your Honor, first of all, I mean, a quick segue on Largo is Largo actually found that the fair market value was $2.7 million, not $850,000. So that goes to Judge Carney's point. The second thing is, I mean, I have all these questions.
Yeah, because this is, you know, I know
Alpert,
we're hitting you left and right. This is a little bit, you know, complicated.
Yes, Your Honor.
But let me do this. With Judge Center's question, let me refine it a little bit so maybe you can answer that. I think his point was to establish that there was some type of sham. You know, you probably, you know, a way you could have done it, and maybe there's other ways, is to depose the doctors that allegedly were not going to renew their leases. And if they said, oh no, we were going to renew our leases, then I guess your argument might be that there was no reason to do this because it was a viable entity. Now, I assume their argument in opposition is going to be, no. What we wanted to do was get all the interest of this membership into all the doctors to encourage, as they did, Buffalo Neuro, to take more space, and then it would be 100% occupied by the doctors, which makes it stable, and that was the intent from day one.
Right. Well, to go to that point, Your Honor, there's a couple things. One is, yes, we did not depose the doctors. We especially did not depose Dr. Douglas Moreland because the divorce was not amicable, and we didn't think that there would be anything productive to be gained by deposing Dr. Moreland. I also would like to point out, though, however, that the respondents did not introduce any affidavits whatsoever by Dr. Moreland or any of the other doctors in dispute, stating why they transferred their shares for no consideration and then took them back 6 weeks later. If I'm a doctor and I'm trying to, we're negotiating for a lease, I don't give up the shares I already have and just take them back. I want more.
They didn't transfer them for no consideration. Weren't they offered the same value? They were offered $8,500 per share, but they weren't going to receive the money immediately.
Well, there was no promissory note, Judge. There was no cash, no promissory note, nothing.
There was no oral agreement?
There's no oral agreement as established by any affidavits by the doctors. I mean, the doctors signed these things, went on with their practice of medicine. They got them back 6 weeks later. It was how to negotiate to get more membership interest is not to give up the ones you already have.
Yeah,
Defies logic.
But tell me this, your real theory, as I understand it, is that there really wasn't a financial crisis. It was a sham. It was created in bad faith, and this allowed for this drag-along sale. So getting back to Justice Center's question, wouldn't you have to establish to show this sham that there really was no crisis, and the only way to prove that would be to establish that this current situation was viable? In other words, the expiring leases, not just Dr. Moreland who took more, but there was other doctors who you know, allegedly, at least from opposition perspective, were probably not going to renew their leases. And the other thing I think you would have had to establish to say it was a crisis, that to prove that these folks did have a way to pay this balloon or were willing to do it.
Right. Well, I think there's questions of fact on all of those issues, Judge, that precluded summary judgment. One of them, for example.
Question?
I'm sorry?
Is this a burden question?
Yes, the burden is actually on the respondents, not just because it's the motion for summary judgment, but because pursuant to Alpert, the burden is not the plaintiff's burden. The burden is actually the respondent's burden to establish these things. And that's because...
Once again, the respondent came forward with some affidavits. At the time that this came about, we have to give me this much, at least 49% of the leases were in question.
that's a question.
And I'll put this, well, Well, we know at the end of the day, 34% didn't renew.
Right.
We do know that.
Right.
And so their position was, it was 49%. So once again, the viability for a balloon payment that was due in February of 13, that was worth a few $1 million, the viability, their concern was, how do we go to a bank, how do we go to an institution and refinance this thing when we have potentially 50% vacancy? So how do we cure that? And they came up with a way to cure it, which ultimately it did, and it ultimately proved to be successful.
I could not disagree more, Your Honor, respectfully. The reason for that, 15% of those, one lease did not expire till February of 2013, after the mortgage was already obtained. Another lease did not expire till March of 2013. Those are the two 15%. I will also point out that this scheme to transfer membership interest to these new leases was not successful with those, because when respondents eventually did get in new tenants in 2013, membership interests were not granted to them until much later. So this idea that we need to have all these membership interests to get new leases, they got the mortgage anyways. The other thing is, you have to remember, these doctors have an interest in maintaining this building and the value of their own membership interests. Dr. Moreland's practice, for example, the lease did not expire until 2018, 6 years after all of these events were occurring. So
yeah, but in all fairness, when you look at the, what is it, the June of that year or September, I get the dates mixed up, they included the doctor's lease was still there. They didn't say we could potentially lose his lease. They said he's part of the 51% that we're retaining. So that was part and parcel of their calculation.
They did, but they do rely on that as part of the financial crisis. And my point is, if you have this money invested into this building and you have these membership interests, the idea is not to walk away. When you have 6 years left on your lease, he had every reason in the world to continue. And I point out that he got his membership interest back, plus my client's membership interest. Every doctor got their same membership interest back after about a 6 to 8 week period. And these are all, as you can see as we're discussing this, these are all questions of fact.
Yeah, so in other words, you're saying under Alpine or Alpert, the force outs are, they're allowable to force out a minority, and you have to show an independent, but they have to show an independent business purpose, and you're saying there was a question of facts as to that.
Yes.
But now getting back, because I know your time's running out, getting back to the next issue, you read that case also to say that, but even if you do have an independent business purpose, you still have to show that there was a fair market value offered to the plaintiff. And you're suggesting, or your argument was there wasn't.
Yes, Your Honor.
Now I'm going to get to a question. So you say that you created that question of fact because you've got an affidavit from, it's Cerconi? Is it
Mr. Cerconi, yes, Lou
Cerconi. Yeah, from Mr. Cerconi that says that the value was much more than what they offered. Right. And just on that ground, you get your day in court on that.
Just on that ground, but there's so much more though, Your Honor.
Yeah, now what about the argument that from, I guess, it's not just, they say, not just that, hey, look, you used the wrong valuation date of, September, because these acts took place before that. But they're saying, in addition, you're using factual data that was after they cleaned this business up, or this, this entity up, and that you shouldn't have. It should be valued based upon the date of the freeze-out. And at the date of the freeze-out, there weren't as many tenants, and it wasn't, is financially viable.
Well, I disagree with that, Your Honor, because as I said, 15% of the ones they were relying on did not expire until February or March. They did give notice that they were going to terminate, but there was plenty of time to find new tenants, and in fact, that was done.
So didn't you need to, with your affidavit, though, didn't you need to say, look, at the time of the freeze-out, this is what the picture would have looked like. In other words, these leases weren't expiring, this is what the income that was coming in, and this is what, based upon an income approach, the value of this building would be. And did you do that?
Well, one of the reasons, no, our expert did not do that. And one of the reasons was is because even though we requested these financial documents, the respondents did not produce them. They did not even produce them during the summary judgment motion to support their own
expert affidavits. We requested the names of these experts. We requested the names of these fact witnesses. They were not disclosed. We requested financial statements. They were not disclosed.
Did you make that argument that continued discovery was needed at 3212? What is it, G, I think?
Well, we had already requested the discovery, Your Honor. They didn't produce it. It was mentioned at various
motion to
conferences.
compel or anything like
no,
that?
Your Honor. My client does not have a significant amount of money, Your Honor, and it was a lot of this case is a question of finances. After she got divorced, this was her income stream. The divorce was settled, thinking that this was her income stream, and it went along for 6 years, and then it was taken away.
So really, what it boils down to is the bad faith type of is really what they paid her for her interest in it, the $170,000.
The $170,000 was way too low, Your Honor.
So it's way too low. So therefore, that was bad faith.
Right. And I'd like to address just a couple points briefly, just to kind of answer some of these.
You've answered our questions. You don't agree with much we have to say, but.
Right. Well, I'd like to point out that the June 2012 date was actually not the date of the drag along. It was actually the date that they requested her to sign and consent.
Correct, we know that.
So that was something different.
Yeah, your date, you say September 5th is the date. That's the date the plaintiff was informed her membership interest was transferred to AM2.
Yes, and that was the
They
date.
say that the date should be June or July, the date the drag-along rights were exercised.
Right. However, if you look at the record, the drag-along rights requests her consent. It does not request, and nothing happens after that until September. In fact, if you look at the timeline prepared by Huck, the respondent, at no time did it say that there was a sale in June or July of 2012.
Let me ask you this. The court really didn't pick a date, did they? The lower court?
I think the court picked the date of July, Your Honor. But I
Okay.
think that there's also, again, questions of fact as to which
Directly
date is
or
appropriate.
implicitly, you think?
I'd have to go back and look. I believe it was
We'll look at
definitely
it.
implicitly. It might have been directly. And one final thing, if you look at the record, it's record 719, where it's the distributions. This is another document prepared by the respondent. From 2003 to 2011, a 20% membership interest would have been $25,000 to $35,000. The first three columns, her shares were doubled because she had the 40% that was pre-divorce. Then there was nothing in 2012. So we have three kind of interesting discrepancies there. One is that there is 3 distributions made in 2013. 2, if you look at the chart, it says for 2013, as opposed to the dates which are present in every other single year from 2003 through 2013. And also, instead of the normal $25,000 to $35,000 in distributions, a 20% membership interest was $210,000 in 2013. She received $170,000 for the full market value of her shares a few short months prior.
Okay, thank you. Good morning.
Good morning, Your Honors. May it please the Court. Michael Willett for the defendants. On the last point, if you look at page 492 of the record, there's a notice that says that the drag-along rights were exercised on July 3rd, 2012. That's a notice to the plaintiff. So that's why we used that date. We've had a lot of argument that there's disputed issues of fact. The problem is that there's no evidence to support the plaintiff's positions. This is a pretty clear, I know it's a complicated record and there's a lot of facts and a lot of documents, but we did that intentionally. We documented to show that this was a restructuring brought about because of financial necessity.
Okay, let's assume you get there. I understand your position. Your position is look, we can do this. And you can call it what you call it, but you can freeze out or close out a minority interest if it's in the best, interest for the business.
But that's not really the intention, Your Honor.
I understand.
I'll let you ask your question.
I may be overstating the rule, but bear with me, okay? Your point is look, right from the beginning, this is what our intent was. Our intent was to get a bunch of doctors to own this building and then require or have them lease the space there so that there was some stability and it would be a good business endeavor relative to running this building. And that the only reason that the plaintiff had some of these shares or this interest in the membership rather is because the doctor wanted the membership in her name. And so there comes a time where it's not working. And the only way you can redo this is to do it the way you did, so that you can have it fully occupied by all the doctors, and then it's, again, a viable, business.
Yes, Your Honor. But I think the way it plays out is, and this isn't a sham. I mean, the leases did expire. 2 doctors left. Dr. Sonawala and Dr. Bauer's leases expired, and they left, and they had 34% of the building. Dr. Diaz-Ordaz had a lease that expired, and he was month to month for a long time. And then finally, in December of 2012, he re-upped. But it was, and the mortgage was expiring, and the company would have had to come up with over $2.3 million.
And they didn't want to do that.
And they didn't want to do that, and that's in Huck's affidavit. So what it comes down to is, in order to get financing, we need tenants. In order to get tenants, we need to be able to offer incentives, because that's how these businesses work. And yes, for a long time, because of the Moreland's marital situation, for 6 years, they carried one member who was a non-contributing member. But when they got to the point, the pressure point at the end of 2012 and mid-2012, they needed to offer incentives. Buffalo Neurosurgery, in their lease, and it's on page, I think it's 671. Don't quote me, but it's in there. 617. In their lease amendment, in which they agreed to take an additional 5,000 square feet, they have in there that they would get 60% of the shares in PCL. So you have 60% they're in for. You get, Huck had 35 all along for being the manager. That pretty much eats up everything, and that's what they had to do. And eventually, they got new tenants. They got Dr. Siddiqui, and they got Dr. Stubbe. And Dr. Stubbe, again, needed 15%. So what happened was, he wound up taking some of the space that Buffalo Neurosurgery otherwise would have taken. So the 15% that Dr. Polina had, when Dr. Polina retired from Buffalo Neurosurgery, he sold it back to PCL and went to Dr. Stubbe. So yes, it did get back to that original intention.
Okay, let me switch gears, though. Let me ask you the question about as I read Alpert, this issue about, now I guess the next argument is, even if there was an adequate and independent business purpose for this, the question is it a violation of the fiduciary, or is it fiduciary misconduct under 417 if the plaintiff was not given the fair market value of her membership?
I think we had to prove that she was, Your Honor.
You had to prove, excuse me?
That we had the burden of proving that she was offered a fair amount for her membership.
Okay, you say you did that through various affidavits.
We did that because we got, and again, this is a very, very, very important point in this case, because the plaintiff relies a lot on stuff that happened after the business was put on a sound financial footing.
I think it was brought up, it's going back, Justice Carney said, you had Besaw, Rubio, you had those affidavits. So the question, let me just ask you this question. Assuming for argument's sake, those affidavits establish the value, okay? Now, she comes forward with, was it Cerrone? Cerconi? She comes forward with Cerconi. Why doesn't Cerconi's affidavit raise a question of fact?
Because he did not do what Mr. Besaw and Mr. Rubino did, which was to look at the value as of the time that the decisions were made that the plaintiff claims were a breach of fiduciary duty.
And your position is...
Those decisions were made in June and July.
And your position is it's not just the date, it's the data beneath the date that was utilized to arrive at
Yes, because
in other words, for the same reasons you did what you did to get this entity back on solid financial grounds, you can't use the data when you straightened it out. You got to use the data at the time that she was required to give up her interest in the membership.
And this is income producing property, and it's just a fact of the real estate industry, and we've seen a zillion examples of it in shopping malls and the HSB Center.
Rents.
If you have tenants and you have rents, it has value. If you don't, you're in big trouble.
But so you see the problem with this? I mean, I understand when we walk through this intellectually that your arguments seem to make sense. But when you look at this afresh and you look and you say, how could we're dealing with a matter of months? And now all of a sudden, boom, this asset went from X to 2 times X in value.
But again, Your Honor, yes, and it did because the situation dramatically changed. And that's, if you look at Mr. Cerconi's affidavit, the last one. He relies on the Northeastern appraisal. That was dated January 18, 2013. That's 7 months after all this is going on. What happened in that intervening period? They got new tenants. They got Buffalo ENT, Dr. Diaz Ordaz, renewed. They got Buffalo Neurosurgery to basically offer to take over the rest of the building. And they got the new financing. That's why it's different. And you can't base an opinion on that when you're judging facts as of June and July.
Okay, thank you, Counsel.
Thank you, Ron.
1306 Perchia v. Bennett. Good morning, still.
Good morning, Your Honors. May it please the Court. The subpoena in this case is clearly an attempt to obtain extrinsic evidence to try to impeach Dr. Riegler on a collateral issue. In other words, to show that he's got a defense predisposition. And plaintiff admits as much in his brief. Basically says, well, if he receives compensation for his time performing independent medical examinations, then his opinion is suspect. That's the conclusion that the plaintiff wants the jury to draw, and that's an improper conclusion. I mean, as this court has held, records regarding compensation in unrelated cases is irrelevant and immaterial to the facts at issue in this case. And there's a reason for that. There's a reason compensation in other cases is irrelevant and immaterial.
We recognize the reason, but what do you have? Was it Dominici? Dominici?
Yes.
Does that speak to the issue of discovery of those documents?
Well, not in this case, Your Honor. Now, first of all, Dominici, all it held was that the judge didn't abuse her discretion. That was the
Because we're dealing with a subpoena, and we're dealing with whether it's utterly irrelevant.
The subpoena in that case, which is all that was permitted, was a limited period of time, 3 years, of records from State Farm to that document.
Okay, so now what I look at is, when I look at that case and I look at this case, here's what I see. I see that they're seeking billing and payment records. They're seeking related other stuff from resident doctors at Riegler, from the insurance company and from the attorneys, and they're asking for 5 years. So when I look at that case, and I look at our case here, I see our case is asking, I personally, I see it similar in nature, but it asking for much more than maybe that case had given.
Yes, Your
So,
Honor.
but you don't seem to be coming here saying, Your Honor, they're entitled to certain things, but they're not entitled to as much as they're asking for. You're coming here saying there's no basis for them to ask it, and I think that that ship had sailed on the other case when it goes to showing bias. And I think and at the end of the day, somebody getting paid to testify on behalf of let's say, the defense, or, in this situation, obviously, it's the IMEs, is that how much income they're making. And there wasn't that one case where, what's the doctor's name? Does the Lifesco? Then the case we had, where, we allowed those records were put in evidence as how much his annual income was for 10 years.
Well, Your Honor, there's a couple things here,
Okay.
so let me back up.
Okay.
I believe Dominici was improperly decided, so right off the bat.
I know, but the problem is it may be improperly decided, but we're dealing with that. So so it start out with, instead of your argument, in my view, should have said, Your Honor, I think the Dominici needs to be disavowed. Because if you're not distinguishing this case from Dominici, then of us to reach your determination, we'd have to disavow Dominici. So you're either arguing we disavow Dominici, or this is the same as Dominici, except this is going way too far, and you're only entitled to some of it. So
Judge, I think I can do both.
Okay.
I think I can do both.
Let's
I do
assert
believe
this.
that Dominici should be disavowed, because in that case, basically what you're saying is, because there's compensation, then therefore the opinion is flawed. And there's a problem with that. And what that opens the door to is, so now defense counsel is going to say, all right, well, I'm going to bring in 10 reports wherein the individual was compensated for their opinion, compensated for their time reviewing the records and doing the exam, but I received an unfavorable opinion. So therefore, the mere fact that they received compensation on this case does not mean that their opinion is flawed.
Can't you ask them in cross-examination simply, you've gotten paid $1 million, did you ever get paid X amount from plaintiffs, or ever found, on a percentage of what you do, you ever found that there was a valid claim at what your percentage is? Isn't that ripe for cross-examination?
Absolutely. This is not a case about cross-examination.
Well, it ultimately will lead to cross-examination if it gets in.
Well, the questions can be asked. Do you make money doing defense examinations. Absolutely, that question can be asked. This is different. This is attempting to obtain extrinsic evidence on a collateral issue. This goes down to the doctor's credibility. He's trying to say, you got paid, therefore your opinion is wrong, flawed, you're lying. That's basically what he's trying to argue. And I'm saying, again, unrelated cases, compensation for unrelated cases is irrelevant and material. That's what the second department, the third department, and this court has said repeatedly. And that's because you don't know the facts behind those other cases. Again, and then to know the facts behind those other cases, you're going to have to bring in the reports, and you're going to have to say, well, in this case it was unfavorable, in this case it was favorable. That's opening the door. It's getting away from, was this plaintiff injured? What are the bases for the doctor's opinion in this case? What did they review? How long did the exam last? Did he have prior records? Did he have post records? That's what these cases should be about, not you made $1 million, therefore you're lying to this jury. And I think that's really the flaw with these subpoenas. So that's why I think Dominici should be disavowed. I think you can distinguish Dominici, however, because in this case, the argument is that it goes to bias. So in Dominici, what this court found, I believe, okay, State Farm, there's an entity. There's an entity that's directly hiring the doctors. You want to show that there's a bias between those two entities, then we're going to allow you to do that. Or we're going to say it's not an abuse of discretion to allow that discovery. I'm wondering how you get State Farm Insurance into the case to begin with, but I guess that's an issue for the trial judge. In this case, what the plaintiff is asking for, all records, every attorney, every insurance company, every defendant, okay? All the money that you make, that goes to a defense predisposition. That doesn't go to bias unless you're just saying, well, you're biased on behalf of all defendants. Okay. That's a defense predisposition. I wanted to correct a couple things in the record that I think are misleading. It's implied that LegalMed, who is the vendor in this case, employs the doctors. The impression that has been trying to give to you is that LegalMed has this stable of doctors that they pay, give wages to, and they just churn out these defense exams. That's not what these vendors are for. These vendors are solely to facilitate the communication between the attorney and the doctor. They help collect the medical records. They collate them. They give a room to do the examination. And they do this for plaintiffs and defendants. Okay, this isn't just a defense. They do it for medical malpractice cases. They do it for film reviews. So to give this impression that LegalMed is some, instrument of the insurance companies is just completely false. And again, if you're saying LegalMed has to give over these records, again, that's for everybody, every defendant, every insurance company, every plaintiff. And so again, you would have to go into court and say, look, this case that this doctor received compensation for, they were actually doing it for a plaintiff in a med mal case. This case, they were doing it on a film review for a plaintiff. This case, they gave an unfavorable opinion. So it doesn't go to this argument that they have a defense bias or that their opinion is suspect. And to sum up, Your Honors, in my opinion, this subpoena was served, there wasn't even a trial date scheduled. This is a discovery subpoena, which is improper for all the reasons set out in the defense counsel's brief. In my opinion, this is intended to harass. This is intended to harass the doctors, to harass the vendors, and be a disincentive for doctors to do IMEs. It's difficult enough to find doctors who are willing to set aside part of their practice and do these IMEs and come into court and testify. And when they're asked to go through their financial records, their tax returns, their 1099s, again, it's not a proper subject of cross-examination or for the extrinsic evidence on the collateral issue.
Thank you, Counsel.
Thank you, Judge.
Morning. I'm obviously not Mr. Bowen. I'm Valerie Barbic here in his stead. I, too, would ask the court to disavow Dominici. I think there's been a complete abuse of the court and abuse of that case to try to broaden the plaintiff's rights to discovery of experts. Expert disclosure is governed by CPLR 3101D, and this was a subpoena served without any trial date, without a note of issue filed, and it's just an attempt to broaden 3101D for no reason. And I would agree with Ms. Banker's comments about the difficulty and where we can see where this is going, and it's to basically intimidate and dissuade doctors from doing defense exams when the defense is already at a disadvantage to find a doctor, you know, to do the exams. And I think that I would prevail upon the court to stop the abuse of the Dominici case. It's called upon more often than it should be, and many times in
certain... Is your position that Dominici is used for greater purposes than what it says, or that it is being used for what the holding is, and therefore it should be disavowed?
It is being utilized to go beyond what it says, and I don't agree with the Dominici decision, because I think it runs afoul of this court's prior decision and Believa versus State Farm and the other departments in Fazio and Pernice, where they say, look, you cannot impeach general credibility of a witness. And what more could you use it for if it wasn't to just impeach the general credibility of the witness? Because we can't have, you know, 100 mini trials within the litigation that is before the court. So I just think it's being abused, and it's for that reason I would ask the court to disavow Dominici. It does not set squarely with this department's decision on the fact you can't impeach the general credibility of a witness, and that's uniform across the departments. And I think that you know, this is just being seen numerous times, and the only thing I can infer is that the intention is harassment. Thank you.
Good afternoon.
Good afternoon, Your Honors. May it please the court, moving counsel. Ron Wright on behalf of respondent plaintiff. Your Honor, we ask the court to affirm Justice Taddeo's decision for essentially two reasons. First, obviously Dominici is the law of the land, and I would submit correctly decided and on point.
It's an easier argument for you because there's 3 judges here that said on that.
Perhaps so. So I'm already ahead of the game, relying on that. And secondly, it would paint what would definitely be a inaccurate, aired picture to a potential jury. I would submit that Dominici does exactly grant the right to obtain and to discover this information unrelated to the litigation at hand. That's just by reading the Dominici decision in and of itself, because Dominici was limited to records from 2009 to 2011. There's no way that the records from 2009 had anything to do with litigation at or after 2011 or 2014 when Dominici was decided. So implicitly, Dominici stands for the proposition that insurance payments made to an expert outside the subject litigation will always go to bias. Because if they went to general credibility, that would obviously be barred in some fashion. There is a line to be drawn between...
What's the difference between bias and general credibility?
And thank you for asking that, because before I came here today, I actually had to look up the definition myself, because they do get very, very muddled together. And really, credibility, I would submit, is the quality of being trusted and believed in. Bias, on the other hand, is a prejudice or inclination towards one side or the other.
Well, bias affects credibility.
It can, but you can also have one without the other. I would submit that opposing counsel and myself are absolutely credible, but we're both decidedly biased in favor of our clients and advocating. So you can have one without the other, and it's a very, very important line to be drawn. For instance, take the analogy of defense payments, whether it's made by an insurance company, IME vendor, or directly from a law firm, and flip it onto the plaintiff side. It's still just as relevant that doctors like Dr. Lifeso have been paid $10 million over the course of 10 years. That directly goes to bias, and that's exactly what Dominici is designed to address. I don't see how the truth becomes abusive because it's put before a jury. It can never be. Now, if they weren't getting those payments, or there's some kind of situation where that wasn't money that was properly allocated to them, then by all means. But having to disclose payments that were made, paid to you for your opinion, and put before a jury who's a trier of fact to be able to weigh that, by no means becomes abusive in any manner. And the subpoena in this case, I would submit, was a subpoena that should have been presented in Dominici for an accurate picture to be presented to the jury.
Would your argument be that the information that was being sought should be allowed because of establishing bias, and it would be up to the trial court to ensure that it doesn't then bleed into the general credibility area?
Absolutely. I mean, there's as the gatekeeper of the evidence, the trial judge has a number of different things that he or she has to look out for. Obviously, potentially injecting the issue of liability insurance into a trial that the judge has to be mindful for. making sure that it doesn't bleed into credibility, limiting instructions. There's all these different tools that are available to the judge. But what happens here, and I reference this in the brief, it becomes very dangerous, is that take Dr. Riegler, for instance. And in this case, he testifies in front of a jury, and I have a Dominici-approved subpoena, or a Dominici, I should say, limited subpoena. Assume that he's only been paid $10,000 over the course of 10 years. Well, the jury's going to look at and compare it to plaintiff's doctor who's been paid somewhere in the ballpark of that same amount to be able to take time from his practice to testify and put them on the same plane. Now compare that if I had a post-Dominici, a subpoena here, that covers all carriers, all IME vendors, and he's been paid $10 million. The same doctor presented to the same jury and going into the same crucible of truth is no longer perceived the same from the jury. The only thing that's changed is really the truth has now been able to be put in front of the jury. In terms of Dominici's limit, I wouldn't classify it as a limit. I don't think the court was seeking to do that when the Dominici.
Well, I mean, at the end of the day, I think it was references the fact it's discretion of the court. The court could have simply said 3 years.
Rightly so, absolutely. I mean,
so it's really left to the sound discretion of the court as to how far it went and whether it went too far.
Absolutely. Okay. Absolutely right.
I think we have your argument.
Okay. If there's any other questions? Thank you, Your Honor.
1307 Jones v. Town of Carroll.
Welcome back.
Good morning. Paul Webb on behalf of the defendant, Town of Carroll. The town's position is that the Supreme Court erred in allowing Sealand Waste to intervene in this action. The action was not, or their motion to intervene was certainly not timely under the CPLR, either section.
One of the arguments you make is there's no action pending. I mean,
That's
there is an
correct.
action pending.
There's no action pending.
Oh, how do you come to that conclusion?
How did I come to that conclusion? Well, after this, originally there was a summary judgment motion in Supreme Court, and that they declared the 2007 law unconstitutional. It came up on appeal to this court. This court vacated that declaration as to the constitutionality and declared the rights of the plaintiff in regards to 5 of their 6 causes of action. That was 1, 3, 5, and 6, and indicated that the seeker cause of action, which was 4, was not reached because Judge Dillon had declared the law unconstitutional, and the court declared that the contract cause of action number 2 had been abandoned. When it went back to the Supreme Court.
Let me just interrupt you. When the case, I'm just looking at our 2014 decision.
Yes.
I don't think we declared the rights of any parties. We vacated the declaration that was made by Supreme Court, but we said that there were questions of fact, I think, on 3 of the causes of action. So it seems to me that there are still issues that, at that point then, when it got sent back to the trial court, there were still issues that remained to be litigated relative to the 2007 law on those 3 causes of action.
The plaintiff's attorney at that time, Tony Nozak, and myself, Mr. Nozak concurred or felt that the decision indicated that the plaintiff was not going to be able to recover on his 1st, 3rd, and 5th cause of action, and the court indicated the collateral estoppel did not apply. The plaintiff then wanted to get the court's...
Well, there's a difference between feeling confident about a cause of action and the court declaring the rights of the parties. I mean, we just didn't do that. The way I look at it, on those 3 causes of action, the 1st, 3rd, and 5th cause of action, we said there were questions of fact, and we sent it back.
You said there was questions of fact in regards to seeker because they never reached that determination. You didn't, I don't believe, indicate that there were questions of fact in regards to 1, 3, 5, and 6. You specifically said collateral estoppel did not apply. Right. But regardless,
but anyway, okay, go ahead.
Judge, what happened was that the plaintiff at that time wanted to get this the appellate division's decision into a final decision, so it could take an appeal to the Court of Appeals. And as the court knows, the Court of Appeals jurisdiction under the Constitution, the order has to be
finality.
Okay, so what happened was that Mr. Nozak, Attorney Nozak, represented.
Right. They moved for leave. Leave was denied.
Well, before that, Attorney Nozak discontinued the second and fourth cause of action and represented to the Supreme Court that the purpose of discontinuing those causes of action was to get this court's order into a final order, the November 2014 decision, into a final order that could be appealed to the Court of Appeals.
That may have been his intention, but the fact that he tried to do that doesn't mean that he actually achieved that.
Well, that could be, but and that could be an argument. But the representation was made in the order, which was signed by Judge Dillon, that the order was being signed for the purpose of finality to appeal to the Court of Appeals. Now, we do know that you can only appeal to the Court of Appeals if the order is final. That's under Article 5 or Article 6, Section 3 of the Constitution. And the Court of Appeals has determined in Berkey versus Carson, and in their outline that they put out on jurisdiction because they scrutinize these motions as to finality, that finality means that there's nothing further that can take place. Now, after the order was signed, dismissing or withdrawing those causes of action, discontinuing those causes of action, they made an application to the Court of Appeals for leave to appeal. That application or motion was denied. And there's a distinction between being denied and dismissed. And you raised the question, how do I know that it was final? There's nothing that can be inferred from the Court of Appeals denying it. We don't know the reasons why they denied it.
I know you've been going through, here's the confusion, because I was on the cases. And my confusion is this. No matter what counsel down below thought, no matter how they presented it to the Court of Appeals, whether you're right or whether you're wrong, we know because we know we wrote the decision.
Yes.
So the question becomes whether counsel were under the mistaken belief that it was final, whether the Court of Appeals was under potentially, I wasn't there, I didn't see what was written, may have believed that was presented to them that was a final order. But at the end of the day, it's up to us to determine whether or not that was what we intended by our decision. So, you know, to sit here and argue somehow or another because counsel agreed it was final, because they appealed to the Court of Appeals because they believed it was final, they led Court of Appeals believe that it was final, that somehow or another our hands are tied on a decision that we might not have that we might not have written up as being final. So that issue, you're beating a dead horse on it. You may be right, it was final, but you'll hear from us on that issue.
Well, let me just say this. The Court of Appeals, when it denied this motion, actually accepted jurisdiction. So because their decision, which is at 190...
Counsel, we'll go to the next point. I'll tell you the reason why. Because if we disagree with you, you'll have an opportunity to bring this to the Court of Appeals, let them know what that means. But if we agree with you, then it doesn't get there.
Yes, but let me just make this point. When the court denies leave to appeal, which they did in this case, they also denied leave with costs. And Judge Pickett and Judge Faley took no part in that decision. So the Court of Appeals took action. That means they accepted jurisdiction.
So I know, listen, this is not falling upon deaf ears. My colleagues up here, we recognize, okay. You're saying to us, and you did in your briefs, is that because of what they did signals the finality, which may, in your view, divest us, whether it was final or not, divest us to do anything.
Your point is it doesn't matter what we think we did. When they took it on, they took on jurisdiction. That's the end of the day.
Well, if they did not feel that the order was final, they would not have denied it. What they would have done was dismiss it and said the order was not final
let me ask you
under the Constitution. That's what they do. They'll tell you that it's not final.
Let's get back to Judge DeJoseph's question. I don't know, maybe I don't understand it. Where is causes of action 1, 3, 5, and 6 in all this?
Where are they?
Yeah, didn't they get sent back down?
They got sent back down. And what the plaintiff contended was that this court did in fact declare their rights, and because this was a declaratory judgment action, you don't dismiss those causes of actions, you declare their rights. And that's what the plaintiff put in his jurisdictional statement to the Court of Appeals. That's what he represented to Judge Dillon. That's why Judge Dillon signed the order, and it specifically says in the order that they signed that it was being final. And finality...
And what is your position where they stand now?
Well, what happened was that Judge Sedita concluded that the order wasn't final, and that those 3 causes of action which were declared, or we feel they were declared, are back allowed back before the Supreme Court in a complaint.
I understand. That's where I was a little lost. I thought it was like just a given. They can't possibly be final. But I get it. I understand what your point is.
And that's why I raised the point, too, of res judicata and collateral estoppel, because they're the exact same 3 causes of action that were in the original complaint. Now, Sealing wanted to...
Yeah, but they were dealing with a different law. I mean, that's really re-arguing the case that was argued before us in 2014. We said, you know, that they were the same 3 actions, but the same 3 causes of action, but dealing with the 2005 law. So the 2005 and 2007 laws were very different. Not very different, but they were different.
No, the 1, 3, and 5 relate to the 2007 law.
Right.
Yes. So those causes of action now are going to be relitigated by Sea Lane Waste on their intervener's complaint.
Okay.
The same 3 causes of action that you decided. So if it goes back now, when you didn't...
But see, that's the assumption. That's where we disagree. We disagree. I think that's where we can agree to disagree as to whether we made any sort of decision on the viability of those 3 causes of action. In my view, all we said was there's a question of fact, and there are questions as to whether the town's actions in enacting the 2007 law were without justification or constituted a regulatory taking. That's how I view our 2014 decision.
Well, the Supreme Court had declared that law unconstitutional. You vacated that determination.
Right.
Now, after it's vacated, I suppose it could go back and Supreme Court could redetermine and say, no, it's unconstitutional again, and we're going to be back up here again on the same on the same causes of action. If they wanted to intervene, they should have intervened back in 2009. It just wasn't timely under either of the statutes.
So that's what I'm trying to get you to move on to. Now, your other argument is the timeliness of the intervention.
Right, and it's extremely prejudicial to the town. I mean, this is 9 years and 15 months after the Court of Appeals denied leave. If they had an issue with what was going on, they should have intervened, gotten into the action a long time ago.
I can't disagree with that.
We have that argument. Okay, thank you, Counsel.
Thank you.
Good afternoon, Your Honor. Alan Knopf for...
I guess I'll ask you the same question I asked someone else this morning. Where have you been?
Your Honor, we did make the motion within a little over a year after the Court of Appeals denied leave.
Yeah, but you've had an interest in this whole thing since about 2004. It's apparent from the record.
Yes.
So,
well, Your Honor, the Jones plaintiffs were adequately representing the case. We're pursuing, as you know, numerous appeals up and down. Our client was deposed. There wasn't a lot of discovery, but the discovery was had, and Jones was adequately representing the interest. They tried to get in the Court of Appeals. I think their funds were running out. They couldn't go any further with it. They hoped to get up to the Court of Appeals, get it decided once for all. That didn't happen. Once it got sent back down to Supreme Court, they weren't going to move it forward, so our client stepped up. And at the same time, the Army Corps actually denied our permit because of the local law. Army Corps said, we have the discretion, we got a lot of it, permit applications, we're not going to mess with this if we think it's never going to happen because of a local law. They said we deny without prejudice because of the local law. So I think that really gave us concrete standing at that point to move forward. So really two reasons. One is Jones was adequately representing us, and then at the point, once it got sent back, they weren't able to do that anymore. And our interest really became concrete because we had the permit denial and we could move forward, and our DEC permits were moving forward. As you know, Judge Sedita granted intervention on two grounds. One is as of right, because our interest, our injury to the property, we had an interest as a permit applicant. We'd agreed on a purchase price, whatever, what wasn't a true purchase and sale agreement, but we certainly had an interest in the property. And then under the discretionary or permissive intervention, common questions of law and fact, which there definitely were. So I guess the only question is the timeliness. The town's argument, I thought, was it was not timely because the case was over, and I think it's pretty clear the case was not over.
Yeah, that's the part I didn't understand with these causes of actions that were sent back, 1, 3, 5, and 6.
Yeah,
I get all the procedural Court of Appeals issues, but
right.
I was at a loss with that.
Well,
and your position is there is an existing.
Sure, there is an existing,
causes of action.
And I'm not going to belabor that because obviously two of Your Honors were on the panel, that the court did not dismiss those claims, but the rule on intervention is liberally construed. It has to be an abuse of discretion to overturn the judge below, and there's been no showing of prejudice.
Who has the burden on prejudice? Do you have to show, does this town have to show that they're prejudiced, or do you have to show that there's lack of prejudice?
I think they have to show prejudice, and they haven't shown any prejudice. You're
the moving party, though. That's why I ask.
Well, we have to show we meet the standard for intervention, but I think really to defeat it, they have to show their prejudice. And they didn't. There's nothing in the record showing any prejudice. We made the motion. The judge said, "Hey, we got a deadline to file a note of issue." We filed our note of issue. There wasn't any more discovery other than we exchanged some documents, and we were done. So there was no showing of prejudice. It's on the trial calendar.
You're basically going to advance the same arguments that the plaintiff was advancing.
Right. All we really did is step into their shoes.
Right.
I mean, they're still
Nothing
technically in the
changed.
case.
Nothing changed.
Nothing has changed.
Other than the names of the parties.
Right. Other than we added the additional party, but the case moves on just as if Jones had the financial wherewithal to continue it, which my client does have.
Thank you, Counsel.
Thank you.
1311, 1312, Key Bank National v. Samil. Good afternoon.
Good afternoon, Your Honors.
Isn't this a real procedural issue? In other words, I was scratching my head. In other words, I think the argument from your opposition is that you didn't argue you weren't given notice of a hearing. You didn't argue that you deserve a hearing below, and now you're asking us for that now.
Well, Your Honor, no, I don't believe that's the case. The case law that we presented suggests that while this department hasn't spoken, several others have. On the issue of how CPLR 4318, 4320 appear to require mandatorily a referee hearing. And in those other departments, the answer has been, well, the referee is there to help the trial court, and if the court needs it, that's fine, but if it doesn't, then the trial court is obligated to deal with issues that would otherwise come up before the referee.
Well, let me ask you this question, maybe a follow-up to Judge Carney's, because I'm a little confused myself. When I look at the record, it doesn't appear that you asked the court, say to the court that, hey, wait a second, the referee erred in failing to have a hearing, or didn't have a hearing.
Or I wasn't given notice of a hearing.
Although it doesn't appear that that was said to the lower court, down below, on a motion to the lower court for your relief.
So it's not, wouldn't be before us if you didn't ask for that.
Your Honor, what is before you is the issue of whether or not the court, being presented with a request to examine the referee and to determine how the plaintiff came up with the numbers it did, declined to allow the referee to be examined or to affirmatively hold a hearing under its own.
But you see, once again, we're getting back to that point. The relief was really to depose the referee, to find out how they reached a conclusion, correct?
Yes.
And you might not be entitled to that. And the question is that if you're entitled to a hearing, as you say now, did you raise that below? In other words, you can't say, I want to depose him, even though you may have a right to have a hearing. You have to raise that below, otherwise it's not before us.
Your Honor, I respectfully look at the case differently. The case law I presented suggests that, at least in the other districts, it's been determined that a hearing isn't mandatory, but if the hearing doesn't occur and issues are in front of the court, then the court has the power to examine that issue.
You're looking for it to be remanded for a hearing, just for a recalculation of damages?
Your Honor, in my view, it should be remanded to the Supreme Court to deal with those issues as the Supreme Court wished.
But there's still a summary judgment there.
Summary judgment's already been granted.
That's done.
But the issue is that a lot of important rights and obligations flow from the confirmation of the referee's report and the granting of the judgment of foreclosure.
Yeah, let me stop you right there, and I'm not trying to give you a hard time. Maybe your argument is that when that was done and you asked to depose, that's equivalent to I want a hearing or I want some recourse. But that's your time to say, I wasn't given notice, I want a hearing, and I don't see that you did that. Let me ask you this, too, on the side. Is this case been settled? Because it sounds like you're still trying to settle this case.
We are still trying to settle this case.
Yeah, that hasn't been successful.
It hasn't, no.
Okay.
I would certainly not be wasting anyone's time if it had.
So if I understand, I guess your position would be that, you're entitled to some due process as to the review of this.
Well, and yes, I am making that point, but I don't think we've reached the other important point. The court denied the relief on the mistaken belief that there had been a hearing. The court didn't deny the relief because there was the opportunity to be heard and we waived it or whatever. In New York, in at least the law in other departments, and Mr. Sarando did a nice job of pulling those cases up, you don't have an absolute right to a referee's hearing. And that is because the court retains the ability to deal with it after the referee's report.
Is that because the real private proceedings and actions law 321 says if required?
1321.
1321, is that why?
Is actually one of several small mistakes in the record below, not in the appellate record. Okay. 1321 deals with unopposed. It provides that you don't need to have a referee's hearing if the defendant has waived or not, has defaulted essentially. Okay, so 1321 had nothing to do with this case, and it's suggestive of the fact that residential foreclosures proceed on boilerplate orders prepared by plaintiffs processing a lot of work. But here you've got the clearest of mistakes below. The court didn't say what you're raising, Mr. Defendant, isn't relevant or it has no basis.
Yeah, they thought a hearing took place.
The court thought a hearing took place. A hearing did not take place. And
that's not the, but that's where for my purpose, I'm a little confused. Because that leads us right back to the first question when we said, did you ask for a hearing? And you're saying the court said you thought there was one, but you'd be in front of us saying, I asked for relief, I asked for a hearing, I didn't have notice, and all those factors are now before us. But when you don't ask for that down below, and you're saying, well, the court relied upon a faulty assumption there was a hearing, but when you made your application, you never said to the court, you wanted to pull.
Yeah, in other words, when the motion was made, that's when you bring it up. You say, Judge, I wanted a hearing, I wasn't given notice. And then if the judge said, you're not entitled to one, or one was given, and you say there wasn't, then we could reach it. Let me ask you just one related, because I know we're beating a dead horse with that issue. I can't find, I was looking at all the various sections with foreclosures. Where does it require the procedures for the referee to give notice? I'm not suggesting there isn't a requirement, but I didn't see it.
Yeah, I'm assuming that fundamental notions of due process say if you must have a hearing, it ought to be
Well, I thought to myself,
a notice.
I tried to look at this from a practical perspective, and I thought to myself, okay, I'm in your client's position, right? And I know that the court is, signs an order saying referee to do this if required, right? Now, what do? My lawyer sends a letter, hey, I want a hearing. Or, in the alternative, if there's a requirement that the referee has to give me that opportunity, maybe there's something in the law that says, look, I've been appointed, you have so many days to request this hearing, and if not, I'm going to go forward with just making my computations.
Your Honor, if I could, I want to make 2 points. One, the court had all the power in the world to do what plaintiff asked it to do at the time, and it denied that on an erroneous basis.
Okay.
Okay? And the second point I would make is this case presents a situation where the motion to confirm introduced a new principal amount that was not in the referee's report. So even if there had been a hearing requested and granted, and everything else worked out the same way, we would have been in front of the court with new numbers, and that was our situation.
Thank you.
Thank you.
Good afternoon.
Good afternoon, Your Honor. John Sarando of counsel for the respondent. The first point, the decision he wants to appeal is not appealable. Number 2, everything he said here, he didn't say in the trial court. He did not request the relief that he's seeking from this court down below.
In other words, below he just said, I want to depose the referee.
I wanted to depose the referee, and he had some concerns about numbers, and then those concerns were answered in the supplement or the reply affidavit of the counsel and his the bank individual, and then the court issued its decision. Insofar as
is there a notice requirement under the law? In other words, once the referee is appointed, is there a need?
I've had the only in my brief experience with a hearing notice, I think I've gotten the letters from correspondence from either the plaintiff's attorney indicating that the defendant has contacted them about that issue, or directly from the defendant's attorney requesting that type of courtesy before I complete my report. I've never had anyone then come in and see me or submit anything to me, but I've had that request. And the third, it wasn't necessary to hold a hearing. I think when you look at the cases and drill it down to the Blueberry Investors case from the 3rd Department, a hearing is necessary to settle disputed facts, and on this record, the way it was presented, there were no disputed facts, and we ask that the order be affirmed.
Thank you.
Court stands in recess.
Exactly. Cool.
Okay, I'll see you later.
Yes.
Yep, you too.